The court's already been through this situation out at this place once before, and
Well, it doesn't mean that there isn't something serious to be brought to the court's attention.
well, I think there's, well, okay. 2 weeks, Your Honor.
How about the 28th, which is the next Monday? That's a better date for the court schedule. August 28th.
Yeah, that's fine.
All right. August 28th.
I'm sorry. That's that Monday, isn't it?
It is.
I have trial that day.
Okay.
Yeah.
All right, we'll do the 25th. August 25th, pre-trial. My question is, video, has it been viewed?
All right, yeah, you're good. Thanks.
State of Ohio versus Christopher J. Blevins, case number CRB 2286.
Your Honor.
19439.
Oh,
TRC 21595.
you're here.
You need time to talk with him?
Yes, Your Honor.
Mr.
We
Blevins
need to
will be
talk.
recalled after he's had a conversation with his lawyer.
In the hallway. I'll be right out.
September.
State of Ohio versus Dale M. Thompson, case number CRB 23237.
This is Mr. Haslam's case. Set for pre-trial.
September 11th, okay. Yeah, 9/11.
Yes.
Okay.
I was just looking, I couldn't remember what the title was. case will be recalled later in the docket.
State of Ohio versus Dylan Hyden, case number CRA 22-473, PRC 22-2096, A and B. State of Ohio versus Jeremy A. McMillan, case number TRC 22-769, A, B, and C, TRC 20-2410, A, B, and C, and others. Roger Smith. Jeremy McMillan.
All right, well, Mr. McMillan's attorney is not here yet, so I'm going to I want to deal with these together. I don't know if you had a chance, Mr. Wolford, to talk to Mr. Hyden yet? Well, there was an incident that occurred. You might want to discuss it with him and Ms. Jones also, and be ready to discuss. The court's very concerned about it.
I was just learning about that, Judge.
All right. Both of these cases will be recalled later in the docket.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Bradley Thacker, Mr. Stratton's case, case number CRV 23-330.
All right, this is Mr. Stratton's case, Bradley Thacker.
Yes.
Is Mr. Thacker here yet, or?
He's not, Your Honor, but the state is going to dismiss this case, so
We were going to ask for the payment of court costs.
Is that something you can do?
well, that's the first I've heard of that.
Did he know that we had discussed it being dismissed?
No, he doesn't. His phone has been turned off, so I've not been able to contact him. I've tried a few times, and it's just off.
It's not set till noon, actually, but.
Yeah. But he's been here every time, so.
And the state still wishes to dismiss even if he doesn't appear, or?
Well, Your Honor, this is a situation in which we had a pretty lengthy discussion with the complaining party, and they agreed that it was appropriate to dismiss the charges. But we feel like we don't want to send the message to this young fellow that we didn't think he did anything wrong. And we would like to have him appear, and we would like to have him pay court costs.
Okay.
We wouldn't ask for a bench warrant right away, but
Well, we're gonna have to wait till noon, or when he shows up. If he shows
Yes.
up, then we can call it, or noon. If he doesn't show up at noon, then we'll deal with that issue then.
We'll just recall it,
And
and,
be recalled later in the docket.
and we can recall Mr. Blevins whenever the court's ready.
All right.
State of Ohio versus Jennifer Brown, case number TRC 23-649, A and B. Mr. Morford's case.
All right, we need Mr. Morford in the courtroom. He's in the lobby, I believe. Jennifer Brown is scheduled for a pretrial.
Yeah. Yeah, what would it be?
3 days. Until suspended to school. No, I believe we're gonna have to change the plea.
And what plea do you wish to enter?
Guilty.
Is that correct, Ms. Brown?
Yes.
Is there a recommended sentence on this case?
Your Honor, this is a first offense. There was a urine test, and they tested for alcohol, and the score was .181, which is, I think, pretty moderate under the alcohol urine. And so our recommendation would be the suspended jail sentence and the 3-day driving school. If the court orders community service, we wouldn't oppose that. A 6-month driver's license suspension and probation and a fine. We won't take a position on the fine.
All right, Ms. Brown or Mr. Morford, anything you wish to say before sentencing?
I don't have anything that I'd defer to my client, Your Honor.
Brown, anything you
Children
wish to
or
say?
anything.
I have a 3-year-old.
You have insurance.
Oh, insurance? Yeah.
She does have a child, 3 years of age, Your Honor, that may be a need in transportation.
Did you have insurance at the time this incident occurred?
Yes.
Do you have proof of that with you? Do you have a World insurance card?
I have it on my phone.
Okay, let's see it. Can you pull it out, please? Well, this one is effective July 1st to January 1st. Yeah, we need one that was in effect
Before
May
that.
27th.
Okay. I can scroll back probably on it.
Okay.
May 27th.
I'd rather do that one. I'm not sure. It's showing see the ID card, but when you tap on it, it's bringing up the new one. Not that one. I've had the same insurance company for like 5 years. I could like call them maybe.
He may end up asking you to do that. We'll see.
Every time I tap on it, it just brings up my new one.
Oh, trust me, he's well versed in insurance and car insurance.
Yeah, I thought.
Wish he could get somewhere like that.
All right, it looks, because there is a renewal document, so it looks like there was a prior policy in effect before July 3rd or whenever that was renewed, so I'll accept Anything else you wish to tell me, ma'am?
No.
So are you a single parent?
No.
Do you have a husband that's helping you, or a father that's helping you?
Yeah.
How many children do you have?
Just one.
One. And are you working?
Yes.
All right, on your OVI, I'll impose a $400 fine, order you to pay the court costs. She gets a 6-month license suspension, and that starts today.
Drive to work.
20 days in jail, and you can show proof that she does have insurance, or did have insurance. Days in jail, all suspended on the condition that you do 5 days of community service. Serve 2 years of jail before probation. You have to go to a 3-day driver intervention program. Unfortunately, we don't have one in Lawrence County any longer. We used to, no longer do we. There are multiple ones throughout the state of Ohio. The closest one is in Portsmouth. And there's a website you can go, and it'll show you all the ones in the state. You can go to any program that's approved by the state of Ohio. Her review hearing will be February the 9th of next year, 24. Review hearings when I check to see if you've completed what you're ordered to do, or in progress, or any good faith effort. If you finished it, everything you're supposed to do, you don't have to come to the hearing. If you have things left to do, you got to show up at 9 a.m. on February the 9th, and if you don't show up, you get a warrant. She had a lane violation charge. I'll impose a $10 fine on that. So you'll need to meet with your probation officer before you leave, Mr. Major. His office is to the left as you go out of the courtroom, make a 90-degree left turn. And it's be right in front of you. Go there, meet with him, get some paperwork, and then you're free to go after that. Any questions?
No. Thank you.
You're welcome.
Thank you.
State of Ohio versus Todd A. Daniels, case number CRB 23-344.
Mr. Morford's case. Anybody that has pre-trials needs to be in the courtroom. Pre-trials in the courtroom, please.
Great. I saw Kyle yesterday. I'm seeing him when I leave here today.
I'm sorry?
I saw Kyle yesterday, and I'm seeing him when I leave here today.
Judge, I have a undated letter from Path in my file.
I have it too. It was faxed to the court on July 10th.
He says that you saw him yesterday.
Yeah.
He saw Path yesterday, and we'll be seeing Path again tomorrow.
When I leave here today. When I leave here today.
I'm sorry, when he leaves here today, he goes to Path.
Sir.
Well, I guess I'd like to know, is he just starting now, or?
I have a letter from July where you've been there on June 23rd. And just going in July.
I can look up all my appointments. I've been there several times.
And it says they have a plan for him that basically says he'll be coming for sessions. I don't have anything since then.
Is this the one from June?
I believe that's the one.
It was faxed to the court on July 10th.
Well, we don't have a problem with him continuing to do that. The next time, we would like to have a little more detailed rundown of what he's actually been doing, what appointments he's made, and things of that nature.
I've been there 12 times at least.
Mr. Morford?
Your Honor, Mr. Daniels offering to call PATH and see if they could get a report to you.
That would be great.
Want to recall then?
One, we just reschedule, let's
Okay.
get a report in here, and also have a report at his next hearing, which I would set for 1 month out, September 11th. Are you available then?
Yes, Judge.
September 11th, pretrial, 10 o'clock, report from Pat.
I'll have him send something when I go down there.
There was a protection order in place, and I assume it's still in place?
Yes.
No change on that?
No, Your Honor.
All right, keep it in effect.
Thank you, Judge.
I've been living there since 2 days after it's happened. No one told me I had an order.
Judge, could I have a minute with the prosecutor before we go to
Sure.
the next case?
Yes.
No one said anything about that. Yeah. No one told me anything about that.
Well, we need to deal with that.
Nobody told
Maybe we'll bring to the judge's attention.
nobody told me I still had a protective order. I've been there since.
Don't say anything right now.
Your Honor, I think maybe this needs to be recalled, and we need to call the alleged
Sure.
victim.
We'll recall it, get her input as to what she wants to see happen, and then we'll recall us, and if the protection order needs to be dropped, it will be dropped then.
Thank you, Judge.
You're welcome.
Stable Law versus Lincoln Hall, case number CRB 23376.
This is Mr. Morford's case set for pretrial, Lake Hall.
We've talked, here's the restitution.
568.
And if she pays that within a month, we can dismiss the charges. No, I'm sorry. The suspended jail sentence.
Here's what they're offering, it's like, you pay restitution of 568, 11 days, and plea constitution of defense. Replace suspended jail sentence, replace your probation. 1 year after you're on probation, see, that's expunged, seal up your record. We'll do that.
Mr. Josh.
Change the plea, Your Honor.
I'm sorry.
Change the plea, I'm sorry.
And what will the plea be?
Guilty, Your Honor.
Is that correct, Ms. Hall?
Yes, sir.
Your Honor,
Recommendation?
yes, and there's restitution of $568.11. And so what we would propose is that if that's paid within the next 3 or 4 weeks, I said a month, so 4 weeks, we come back for sentencing, and we would recommend a suspended jail sentence at that time. But we need to have the restitution paid. So that's what we would ask for, is to delay sentencing until sometime in the latter part of September.
Will the restitution be paid through the court or directly to the
Well,
audience?
I think through the court, that way it can be kept track of.
Jason, do you have an address for the alleged victim?
Yes.
Okay.
Mr. Morford?
Your Honor, my client is in agreement with Mr. Hill's offer and would ask you to accept as a joint recommended sentencing when we get to the sentencing date.
Okay. So I'm going to accept a guilty plea today, and that's what you want to do, Ms. Hall?
Yes, sir.
I'm going to delay the sentencing to give you a chance to make the restitution payments. You'll pay it here to the clerk's office, and then that way there's a record you paid it, and they'll transmit it
Okay.
to the complaining party, and then we'll come back for sentencing after that's completed. And you're saying by the end of September, you can have that done?
30 days, Your Honor. Yes.
About September 22nd, that's more than 30 days.
I'm here then.
Okay. Sentencing hearing will be September 22nd at 10 o'clock.
Yeah.
I'm sure you have that money paid before. Okay. Okay. We'll see you then, Mike. Thank you, Your Honor.
You're welcome.
Thank you.
State of Ohio recalls Christopher J. Blevins, case number CRB 2286, and others.
So, Your Honor, Mr. Blevins was at Regal. There was some serious issues there that he's not blaming Regal. He takes full responsibility for him leaving Regal. And I'll let him explain. I think it might be good for the court to hear his explanation from his own mouth about what happened there and how he ended up at OVP. And it's kind of insightful a little bit too.
All right, Mr. Blevins?
Your Honor, after I came here the last time, I had been holding on to a relationship that was very codependent and was going to work. The relationship ended. I relapsed in the house. I started using with first my roommate, and before a couple days, everybody in the house, including transport drivers. I went to work, and one day I didn't go back. My mom wouldn't let me go home. I went to the city mission. I've never been homeless. And somebody wanted me to get them something. And I went and got them some fentanyl, and we're sitting on the back steps of this abandoned house, and they give me some for getting it. I do it, the smallest amount I've ever done. And I don't know the amount of time because the people that I got it for were gone, but my memory went from the back steps of that abandoned house to standing there soaking wet, my whole body tingly like I'd slept on my arm. And I take my breath and I look, and it's the guy I got it from. I have no idea how he got there, but he said, "I need you to calm down. You was in that mud puddle, I don't know for how long." He said, "I only had 3 Narcans. I used them on you. Your friend's around the corner." I looked around the wall. He was contorted, foaming at the mouth. He said, "I don't have any more Narcans. I used them all on you." He said, "Go pound on those apartment windows." So I went and pounded on the apartment windows, eventually found 2 Narcans and saved him. Went back to the mission, and I looked for the recovery coach, and I said, "I need you to get me an OVP. I'm supposed to be in a treatment center. I need to get an OVP." And it was going to be 4 or 5 days before I could get a bed, so I had him take me to outpatient and get enough Suboxone until I could get in there, because it was really traumatic. And I got the OVP. I've been there 2 weeks. I knew I needed to try something different, so I asked for the Sublocade shot. It's ordered right now. I've been clean 2 weeks. I'm doing really well, and I understand I need long-term. I knew I might be in trouble with you. Even if I was in trouble with you, I know I need long-term even after whatever you had in store for me. I know I was very close to death. And I don't want that I don't want that to happen. So I've been doing good. I'm no longer doing it because I have to. And I knew I had court today, and I've never missed a court date.
He's always been here, Johnny.
Well, you're either a very good actor, or I see a change in your attitude from what I've seen in the past. So, you're saying the right things. You know, time's going to tell whether you're really committed to this or not. And I hope you are. Well, as you know, and you've lived it, it's really dangerous out there right now. Fentanyl has taken a lot of people out. It's a whole different ballgame with fentanyl on the street. So you literally dodged a bullet that day. So I don't know how many bullets you can dodge, but hopefully this has convinced you and you're committed to your sobriety now.
I didn't call my son one day I was out there. I talked to him every night. He's 7.
Well, that's important.
I want Mr. Blevins to be able to tell that story 1,000 times in the future to help other people. Because that's one of those things that you hear, you know, that you don't forget. And I hope that what this has done has caused him to make a permanent resetting of his mind in a direction where he's going to continue. Because it sounds like it's been quite a shock to his system. And hopefully you put that to good cause in the future.
Well, we need to be thinking, I think this is good that you're at OVP, but you're going to need a longer-term plan after you get finished there. So what's your thinking there? What's the next step after OVP?
I heard that ARC's pretty good. I've heard about ARC. Jeremy Brown's there now. And I know him from when I was at Riverside.
He's in the courtroom right now.
Oh.
Right there in the back.
I always trusted him, so something good and strict and long is what I need.
Okay. Jeremy, you want to talk with Chris? Yes. When we get finished? Okay, I think you're on the right track. Let's get you set up for some plan after you leave OVP. Do you know what's the date you'll be leaving there?
I got there on the 27th.
So around the end of August sometime.
I think it's on that letter, isn't it?
Yeah. Okay, why don't we come back on August 28th? That'll be about the time you're transitioning. You're not available.
Yeah, I'm
25th.
sorry.
August 25th. That'll be about the time you're transitioning to another phase. All right, so good luck to you, Mr. Blevins. We'll help you any way we can. I think you're saying the right things. Hopefully you'll do the right things. Talk to Jeremy. Let's get a plan in place and follow through with it.
Thank you, sir.
You're welcome. Good luck.
State of Ohio recalls Dale M. Thompson, case number CRB 23237.
All right, Mr. Thompson is represented by Mr. Haslam, pre-trial, has some discussions hopefully that were fruitful.
We did, Your Honor, permission to approach?
Yes. I think that might be my bid. Okay. All right, there's some things in effect to resolve this hopefully in the next month, so I'm going to set it for another hearing September the 11th at 10 o'clock.
All right, thank you, Your Honor.
You're welcome.
Thank you.
Okay, we have one arraignment at the court, and then we're passing hearings at the jail. We're going to go do by teleconference.
State of Ohio versus Cassidy Dorigo, case number CRA 23487.
How do you pronounce your last name, sir?
Dorigo.
Dorigo?
Yes,
You're
sir.
Cassidy?
Yes, sir.
All right, Mr. Dorigo, it's alleged by the state, and I guess the bailiff is actually bringing you a copy of the charge right now, that at Perry Township on August the 8th, you not only caused or tried to cause physical harm to Julissa Scott, who's either a member of your family or a member of your household. The charge is domestic violence. It's a first-degree misdemeanor. Maximum penalty is 6 months in jail, $1,000 fine. Do you understand the charge filed against you, sir?
Yes, sir.
Do you understand the rights you have?
Yes, sir.
How you plead to this?
Not guilty,
You want a lawyer appointed?
please.
Are you working?
I do work.
I have to determine your gross annual income. Do you
Okay.
know what that is, or how are you paid?
All right, so I make $2.13 an hour. I work about 20 to 30 hours a week because I'm a server. And so I make, roughly, it's right around $200 to $300 a week, if that.
Okay, you're eligible for court-appointed counsel then. I'll appoint Mr. Morford to represent you. Entering a not guilty plea for you is Julissa Scott here today? Julissa Scott. What's the state's position on bond and protection order?
I don't have,
Well, we have,
that's on right now.
we'll ask for a protection order. And there's very little information in the file that's been given to us about her whereabouts, so we'll be trying to hunt her down. In the meantime, we'd ask for a protection order. We're not opposed to an OR bond, we want to make sure that Mr. Dorigo is not going to be around her.
Yes.
You're being asked, you're being asked to sign no contact order. You cannot have any contact with this lady in any shape or form. You can't go around, can't ask others to do it, can't do it by electronic means. Do you understand that?
Understood.
That can be a separate problem in and of itself. You need to sign there and there.
And does he have another place to stay other than with her?
Yes, Your Honor.
When do you want to come back for the next hearing, Mr. Morford?
The judge, once he's out on bond, I'm not gonna hold the state to the time. We'll do it at your convenience.
Well, does he think she would want, if she wants the protection order dropped, she has to contact the prosecutor's office.
And she's able to do that?
She can ask them to ask for it to be dropped. So if you think that's something you would want to happen, then we maybe need to come back sooner than later.
He's asking you, do you think that's something that you can accomplish
Yeah.
quick?
Like, how am I supposed to go about that without contacting her?
He meets on Monday, Friday, something like that.
Do you have a good point? How am
Prosecutor's
I?
office, and we'll be in touch with her too.
Okay, all right.
That's what this is.
Well,
About August 28th, Mr.
Judge, I'm scheduled to have cataract surgery the
Okay.
25th. I don't know if I'll be able to.
Well, we
You
can
may
do it
not, I don't,
next, if he wants to come back in a week, we can do it next Friday, the 18th.
come back next week. All right, let's do that.
let's do the 18th, please.
August 18th will be the next hearing. Pretrial be a protection order in place till then.
Get the file.
Next hearing is at 10 o'clock, August the 18th. You can sign.
10 o'clock.
He's posted a bond. He has a bond up,
Yeah.
and it's continued. Okay, we have a couple more arraignments here in court.
State of Ohio versus Lawrence W. Calderon, case number TRC 231067 A and B, CRB 23486 A and B, CRB 23488. Lawrence Calderon.
Lawrence Calderon. All right. He should have been arrested because he has a warrant out of this court already. They must not check. All right, there will be a capias issued for Lawrence Calderon for failure to appear. He was cited here today at 9 a.m. He's failed to appear. He had an outstanding warrant anyway from an old case from 2019. So I don't know how that happens, but it did. No bond. He'll be held, should be held without bond until he appears in court.
State of Ohio versus Jeffrey A. Trout, case number CRB 21900, CRB 21602.
All right, Jeffrey Trout is here. This was set for July 7th. I'm sorry, August 7th. August 7th was your last review hearing, which was Monday. Looks like you missed that?
Yeah, I couldn't make it. I had my son in, it was going to storm.
You had your son in what?
It was going to pour down rain. I had to take a bus and ride the rest of the way to get here. I had no ride.
Okay, you've paid your fine on one case. The other case, you did make a payment today. Okay, you don't have that much left to do.
Yeah, I'm trying to get it paid up.
Okay, when can you pay it up? 270 is what I'm showing you.
I'm on disability, I mean,
Okay,
I'm just trying to get it paid.
all right, I'll set your next hearing for September the 18th. 9 o'clock, September 18th, 9 o'clock.
All right. Thank you, Lon.
You're welcome.
Ready to go to Lawrence County Jail.
Okay, now we're going to the jail for teleconference, arraignments, and hearings.
State of Ohio versus David Abrams at the Lawrence County Jail. Aaron Atkins is on deck.
David Abrams.
Good morning, Mr. Catter.
Good morning. You're David Abrams.
Yes, sir. I just want to apologize for missing court. I was out of town working for just changed company, so I was out of town working. And I was gonna come, I would make it, but I just couldn't get here. I was out of town.
All right, Mr. Abrams, let me tell you a few things before we proceed any further. As you know, I'm Judge Capper. This is a arraignment hearing on a failure to appear. It looks like you had a review hearing set for
Yes.
May 30th of this year, and you missed that hearing, and a warrant got issued because of it. It was on an OBI Case number 20-2197, driving issues on a license, that's 2014-68. And another driving under suspension, 27-15. Do you admit or deny you missed your hearing May 30th of this year?
Yes, sir, I do admit I missed it.
Do you have an explanation why you missed it?
Yes, sir. I had changed jobs and I was out of town and I was unable to get back in time to make it to court. And I had been doing all my community service. I'm only one day short of being done with my community service. I had been putting my time in trying to get that done before I started this new job because I knew I was going to be out of town.
Okay.
And I do apologize.
But how'd you get arrested? You got arrested on the warrant.
I got off work and was driving home yesterday because the only reason I was driving was because I have a doctor's appointment because I still in recovery at ODP. I still take my Suboxone every day. So I had a doctor's appointment yesterday afternoon and I didn't have a way to get there, so I drove my wife's van to work so that I could come back. And so that when I got home, I would be able to go to the doctor's appointment because she don't get off until 5. And that's when my appointment was at 5, so I had to be there by 5. And I was driving home, and I was going down my street there at Cole Road, and one of the Cole Road cops were behind me. And I guess I have a brake light on in my wife's van. So with that's how I ended up here.
Okay.
And I was able to come to your courtroom like I wanted to, I think. But once I got my 90 days, then I was going to be able to submit the paperwork to the problem.
You're still on probation at your work, is that what you're telling me?
Yes, sir. Yeah, it's pretty close to being over, but
Who are you working for now?
MS demolition.
You supposed to be at work today?
Yes, sir.
Well, you still
That's
have.
why I'm hoping everything goes good and my wife can pay my fine and come get me down here to work.
Okay, I'm showing that you still owe 16 hours of community service and some fines. So,
16 hours?
yeah.
Well, I mean, that's why, that's what it says, that's what it says. I thought I got it down to 1 day, but 2 days. I mean, if that is, it is what it is. And if you want to give me more for not coming to court, I understand that as well.
I just want you to do what you were ordered and stay out of the jail.
Yes, sir.
I mean, as you know, as you can attest, it's overcrowded and there's a lot of people that deserve going there, maybe more than you do. But if you don't come to court, what options do I have? I have to make you go to jail if you won't come to court voluntarily.
And I understand. I'm sorry. I mean.
Okay, I'm going to send you to time served. You have done a lot of what you're ordered to do, but you didn't finish it, so you got to finish it. I'll send you to time served. I'll give you a new review hearing date. Does it matter if it's a Monday or Friday to you?
No, not at the time.
Okay, I'm going to set it for September the 11th, exactly 1 month. You've got another hearing. If you can get everything finished before then, you don't have to come back. If you haven't finished it, you got to come back at 9 o'clock on September the 11th for a review hearing. September the 11th. That is
I was trying to
the second.
to write that down.
Okay, well, you've got Labor Day is the first Monday. Then the next Monday after that, you got to be in court.
Okay.
Labor Day is on September 4th. The first Monday of September is Labor Day. The next Monday, you're going to be in court in Chesapeake, 9 o'clock.
Yes, sir.
Okay, you'll get released by me here shortly. Unless you've got other holders from other courts, you'll get out.
No, I'm good.
Okay, September 11th is your next hearing.
Thank you, sir.
You're welcome.
State of Ohio versus Brittany Caldwell, case number CRB 13-1057, CRB 13-1153, A and B. And James Childers is on deck.
All right, Brittany Caldwell is in jail on my order. We'll have Taylor up to make a statement, but this was set today as a sentencing hearing in any event. She went to inpatient treatment. It's my understanding she was being very disruptive, disrespectful, not participating.
Every bit of that is true.
Sorry, been sick.
I'm reading from your report, and it says, amongst other things that you did, you urinated from a second floor window of the residence, even though there were bathrooms available to be used at the time. You have not participated, just listen. You have not participated in group services. You've been observed going through other people's belongings. You do not take part in helping do household chores. You have made no progress in your treatment, and you are not taking it seriously.
Just haven't felt good.
Well, how do you feel in the jail?
I don't like it at all. It's miserable in here. Somebody's screaming all night long.
It's a place to be avoided, is it not?
It is, yeah.
If I let you go back, and I'm not sure they even want you back at this point, what's your attitude going to be like?
Much better.
Well, that doesn't help me much. Are you going to participate in the sessions?
Yes.
Are you going to help with chores?
Yes.
Are you going to go through anybody else's stuff?
No, I wasn't going through anyone's stuff anyways.
Are you going to do what you're asked to do when you're asked to do it?
Yes.
And it's my understanding she's going to PATH also?
She's going to a new, it's an on-site mental health facility that we have. We would like to request an ankle monitor due to various conversations about running when she got to court, and just because I think it's in her best interest.
All right. There's also been an allegation you've made a lot of threats to run, that you're going to leave, you're going to take off.
I'm not going anywhere.
Okay, well, just to make sure, I'm going to place an ankle monitor on you. And if you cut that off, you're going to guarantee yourself a trip to prison. Do you understand that?
I spoke with Carl Bowen this week. We are at our family limit right now. So, I don't know.
What kind of jail time would I be facing if I didn't go to treatment?
The most that I could possibly give you. So that tells me that you're really not interested in getting clean.
I am interested. It's just 6 months is a long time, and I had just gotten a job and gotten a new apartment and everything. Everything was just starting to fall into place.
You've got 6 months of jail suspended in case number 13-1057. You were ordered to go to treatment and complete it in lieu of spending 6 months in jail. Would you rather spend 6 months in jail?
No.
Okay, I'm going to order her release to treatment, and let's come back in a week. I'm going to keep a close tab on you, so I'm going to see you on August the 18th, and I may put an ankle monitor on you then if one's available.
Okay. Who will be coming to get me today?
I don't know.
Somebody.
Somebody will come and get you. Now, you have to do a lot better. If you don't do a lot better, I'm just going to put you in jail, and then you'll serve a purpose, because you can talk to all the people in jail who may have a substance use problem, and you can tell them, hey, you better take it seriously, you'll wind up like me, sitting in jail. So that may help others. It may not help you, because I don't really think jail helps people get over their substance use problem very much. but you can help other people by maybe scaring them. I'll use you as an example, what happens if you don't take it seriously. So far, you have not taken it seriously.
I will.
So I better see a big improvement, or it's back to the jailhouse for you, or go on the lam. That's the other choice. Break out, get out, leave, never come back. Live that kind of life if you want. I'll see you in a week.
Okay, thank you, Your Honor.
Thank you, Your Honor.
We'll just do it.
State of Ohio versus James Childers, case number CRD 23483, TRD 22816, Tracy Hill is on that.
James Childers. That's you, sir?
Yeah, buddy.
Okay, well, that's not a very appropriate way to address the court. So you're not getting off to a good start. Mr. Childers, you have a right to remain silent. You don't have to say anything. If you choose to make statements, it's all on the record. It can be used against you. You have a right to have an attorney, to have one appointed if you can't afford one. You have a right to bail and to make the state prove these charges beyond a reasonable doubt. Do you understand those things?
I believe so, yeah.
Okay. The most recent charge is case number 23483A, and that alleges that on August the 11th at Union Township, you resisted or interfered with the lawful arrest of yourself. That's a second-degree misdemeanor, carries a maximum penalty of 90 days in jail and a $750 fine. 483B alleges at the same date, around the same time and place, that you committed domestic violence by threatening to use force and causing Christy Pauley, who's a member of your family or household, to believe you would cause imminent physical harm. And I believe this may need to be, well, I'm not sure. It says the harm was threatened against Clarence Mahan. I don't know if that's...
I think we've got the name wrong there. It said, it should be Charity Pauley.
Okay, and you move to amend that?
Yes, Your Honor.
Okay, I'm going to amend it to allege the harm was threatened against Charity Pauley. So that's a fourth-degree misdemeanor, domestic violence, carries a maximum penalty, 30 days in jail, $250 fine. And then there's an older case, 220816. That was a traffic violation where it was alleged March 26th of 2022 at 12:55 a.m. in Rome Township that you were driving a motorcycle without proper motorcycle endorsement. That's an unclassified misdemeanor. Maximum penalty is 500 hours of community service, $1,000 fine, that you were cited to traffic court April 12th, 2022, and failed to appear. Do you understand these charges, sir?
I do not. No, sir.
Okay, well, let me go over them again. You have a domestic violence charge, a resisting arrest charge, and a no motorcycle endorsement charge. Do you understand that?
I understand the latter. I don't understand the domestic because that doesn't exist. And Darren and myself are we're cohabitating, and he changed the locks on a house where I and my children were living, and yeah, that was not
Do you have the money to hire a lawyer, sir?
Pardon me?
Do you have money with which to hire a lawyer?
I do not, no, sir.
Do you have a job?
I do, yes, sir.
Where do you work?
I work for, I work for, where do I work? Yes, I work.
Do you know where you work?
I do know where I work. I've not been asleep all night, so it's escaping me.
Are you paid by the hour?
I am, yes, sir.
How much per hour?
I would have to look at the pay stub, unfortunately.
How many hours a week do you work?
40.
Do you think it's more than, say, $12 an hour or less than $12 an hour?
It's more than that.
How much more? Give me a guesstimate. I have to determine your gross annual income.
Oh, right, okay, I got you. I make 54,000 a year.
Okay, how many children do you have?
I have 3, sir, and my wife is out of the picture, so it's just me.
Okay. Well, you're actually making too much for me to appoint a lawyer for you. So you'll have to hire a lawyer on your own.
Me. Yeah, okay.
Do you, what's the state's position on bond for Mr. Childers? He had, and remember, he has a failure to appear on a prior traffic matter. And he has a West
That's
Virginia.
another thing.
I've got a West Virginia address for you, sir, is that correct? Idle Acres, Huntington?
No, I live in Ohio.
What's your current address?
What's my what?
Current address.
I'm sorry, one more time.
What is your current address? Where are you living, sir?
Oh, yeah, 71 Township Road, 1213.
That's the same address as the complaining party.
Okay. What's the,
Yeah, she and I live together.
what's the post office?
That's a,
I don't know what that
Is that South Point or where?
well, it's Union Township.
Oh, Chesapeake probably.
Yeah.
What's the state's position on bond for Mr. Childers?
Well, we certainly don't want there to be any contact at this point. I was reading through the allegation, the narrative, and there's some indication that maybe they were in the process of parting ways, and there had been an attempt by the complaining party to start an eviction, which never got filed in the court. But so we don't want him to be around her at this time. So we'd have to, I guess, find out if he has someplace else to go.
Do you have a place that you can live other than with charity?
I do not, and my children live with me in that household with charity, so.
Yeah, so the children are with her at this point?
No, they're actually with some grandparents.
Their grandparents?
No. Yes, their grandparents who are elderly and not able to take care of them.
And where,
They've been with me
Are these your parents or their mother's parents?
No, these are my parents,
What's their names?
Ernie and Donna Childers.
Where do they live?
The last count I had, up near around Milton.
You don't know where your children are with your parents and you don't know where they live?
Let me rephrase. My children are with their grandparents in the Procedural area. However, that's on the wife's side. We're doing a divorce, and the children have been with me since they were babies.
And I take it that Charity is not the mother of your children then?
Correct, yes, sir.
Well, it sounds like they're with a relevant placement. I don't know if we need to advise Children's Services or not. What are the names of your children?
Lynn and James, Magdalene May, and Lily Ann.
How old are they?
Lynn is 7, Magdalene is 10, and Lily is 13.
So they're with their mother's parents?
No, sir, they are with godparents who are not actually related to them.
Okay, seems like every time I get a little different story every time.
No, I just don't think I'm being clear.
Yeah. Well, you said mothers, before you said mothers, grandparents.
Yeah, but
Mothers, godparents, I don't know.
Yeah.
I'm concerned for these children that somebody's taking care of them. That's the main thing. And maybe we need to get Children's Services involved.
Yeah, no, see, I take care of those children and.
Well, that concerns me. Yes, that concerns me very greatly, that you're taking care of them. I'm going to set bond at $2,000 cash or surety since you didn't show up before when you were cited in court. You got to post a bond now.
So.
And I'll set a hearing for you next Friday, which would be August the 18th, for a pretrial.
I have to work. Will I be able to?
Well, you know, this trumps work. You got to come to court.
I don't. Okay.
Yeah, you just have to tell your boss, sorry, I've got a court hearing. Now, do you think you can post a bond?
For how much?
$2,000 cash or surety. You can use a bail bondsman. If you got $2,000, you can post it. You get $2,000, you get it all back as long as you show up to your court appearances. If you can't post $2,000, you can use a bail bondsman. You pay them a fee, but you lose the fee, but it'll be a lot less than $2,000. But then if you don't show up, the bail bondsman's going to be hunting you down to bring you in because you didn't show up for the court hearing.
Yep, I will find the bail bondsman.
Okay, we'll have one contact you. Okay, your next hearing is a week from today, August the 18th at the court of custody. Do you know where that is? Okay, it's on County Road 1, about a mile and a half west of the 6th Street Bridge in Huntington,
I think I can find it.
across from the flea market.
Oh, yeah.
You should start.
Kind of upsets me that everybody knows where the flea market is, but they don't know where the court is. All right, 1 week from today is your next hearing. We'll have the bail bondsman contact you.
Sounds good.
And the state will contact Children's Services. Thank you.
Yes.
Check on those children.
State of Ohio versus Tracy Hill, case number CRB 21643, and Justice Johnson is on deck.
Your Honor, can I ask you a question about this last case? What was amended? Because also, some of the things for rights to review, we got those on too.
I don't think anywhere remembers these.
Okay, I thought something was amended. Okay. Thank you.
All right, Tracy Hill, that's you, sir.
Yes, sir.
This is Mr. Morford's case. It's an old case. The allegation is that Mr. Hill had failed to appear for a hearing on a pretrial back in 2021.
Yes, that's true.
Hold on, sir. Just hold on. Don't say anything yet till your lawyer gets in the courtroom. We need Mr. Morford in the courtroom. Mr. Morford, this is Tracy Hill. It's an old case for you from 2021. The allegation is he failed to appear for a pretrial September 24th of 2021. Got a warrant issued, and he's in custody now. So I assume you have not talked to him for a couple of years, and you would like to do that.
Please.
You can have the court's file, call down to the jail, talk with Mr. Hill, Tracy Hill, and after you've done so, let the bailiff know, we'll recall the case. The attorney's going to call down, talk to you on the telephone, Mr. Hill, where I'm not listening in to your conversation.
Okay.
With respect to he is now on the path, and I'll get him to sign anything to sending me like more than one report a week.
Okay.
And Mr. Daniels is on his way back here with written report from Pat.
Okay.
State of Ohio versus Justice Johnson, case number TRC 23657, A and D. Charles Martin is on deck.
Your Honor, this was arraigned on Monday. It's an OVI and a speed. We'll go ahead and plead guilty to both of them. He's been in, I don't know, a little less than a week probably. So I'll just ask that you suspend the rest of the time and put her on probation.
All right, Justice Johnson is before the court. The attorney, Mr. Stratton, is also here. Johnson is in the jail appearing by Blue Jeans teleconferencing. Your attorney says that you wish to enter a guilty plea. Is that correct?
No. I believe that,
What?
last court, what was it? Sorry.
Okay, do you want to talk?
No, we just talked. Mrs. Johnson just spoke about entering a plea to this OVI and speed. We just spoke about that a little bit ago.
Oh, okay.
Remember?
Sorry about that.
Yeah.
Yes, sorry.
So you do, I want to make a good record. You do not have to enter a guilty plea. Do you understand, or a guilty plea? Do you understand that? But your lawyer's saying you wish to change your plea from not guilty to guilty. Is that correct?
Yes.
If you enter a guilty plea, that is an admission that the charges against you are true. You're not going to make the state prove the charges beyond a reasonable doubt, which you have a right to do. You're saying, I agree, I am guilty of the charges, which are operating a vehicle intoxicated and speeding. That's what you're charged with.
Yes, sir.
All right, I will accept your guilty plea. You have a right to make a statement to me if you wish about what occurred, either an explanation or a statement. You're not required to. Do you have anything you want to tell me about this before I sentence you?
No.
What's the state's position on sentencing?
Well, Your Honor, I guess my initial question would be, why is she still in jail? I don't recall what the court did as far as bond, but it was a first offense OVI.
Well, she had failed to appear previously, I think, on the capias, so she had a bond, a required bond, because she had failed to appear initially, and I'm assuming she was not able to post the bond.
So as far as the time that she's been in jail, we would believe that that's probably sufficient as far as incarceration time. We'd ask for an additional suspended sentence, 6-month driver's license suspension, fine, and we wouldn't take any position on community service or other sanctions.
So it looks to me like you've been in jail for at least 4 days, is that correct?
About 6 days. Since last Saturday,
Okay.
about 3 o'clock in the morning.
Do you have any additional charges, or are these the only charges you have?
Those are the only two.
Yes, Your Honor, that's all we have.
Okay. And Mr. Stratton, do you have anything you want to say?
Your Honor, it was a breath test. I think the report talks about...
A 15 breath test.
Yeah, she was cooperative. There was no... she was cooperative in the police report.
Well, let me ask you this. Do you have an explanation for not coming to court when you were ordered to? You were ordered to come to court June 2nd, and you didn't come then. You wound up getting arrested on the capias that was issued. Do you have an explanation why you didn't come?
Yeah, I tried to call, and they said that the court was closed that day, the same day that I tried to call, and I wasn't exactly sure, like, what courthouse or, like, where, like, the directions to get there, or anything like that. I wasn't exactly sure, like, where to go, or where the courthouse was that I was supposed to be at.
Well, right at the top of the ticket, it says, you are summoned in order to appear on June 2nd, 2023 at 9 a.m. in Lawrence County Municipal Court, 10916 County Road 1, Chesapeake, Ohio, 45619. So that's a little incredible to me that you didn't know where to go.
No, I would never run from court date. I definitely like to keep my license. So yeah, I really didn't know like where I was supposed to go. I had a family member that tried to help me to tell me where to go, but like I said, like I was just my first ticket like that, so I wasn't sure where I was supposed to go or show up to.
Okay, well, I don't believe that. I don't believe that unless, are you telling me you can't read? I mean, right at the top of the ticket, this is the very first thing it says.
Right, like I said, like my very first ticket that I've had, and like.
Can you read and write, ma'am?
Yes.
So there is no excuse for you not coming to court.
Just me not knowing exactly where I was supposed to, show up to, that's it.
Your Honor, there's never an excuse to not come to court except being in the hospital or dead. So, Your Honor...
Yeah, I don't think she's getting that, though. In the future, ma'am, when you are cited into court, you might do something other than just call a relative and say, do you know where this court is? And if they say no, okay, I'm off the hook. I don't have to come to court.
Right.
Because you know what? You're either going to have a warrant or a capias for not showing up.
Correct.
And that means you're going to go to jail.
Right. That's understandable.
Yeah. So I hope you learned something from this. I mean, you cannot just blow stuff off.
Right. Definitely did learn my lesson, for sure.
I'm not sure about that. So I'm not convinced. Because you're still trying to throw excuses out as to why you didn't come to court. And that's not, you are a fully grown woman. This is not 5th grade.
Right.
5th grade now. 5th grade, when I was a kid, you had to do more. Now 5th graders get a really big pass. We've bumped that up to about 30. You get a pass through, you're about 30 now, to act like a kid. Okay, end of the rant. How old are you?
I'm 24.
Old enough to figure out where the court is. When it says right on the top of the citation where the court is and its address. And I'm assuming you've got a smartphone, right?
Yes, sir.
So you could Google where the court's located.
Yes,
You're not gonna tell me you don't know how to use Google, are you?
yes, I do.
No excuses. If you put Lawrence County Municipal Court in Google, it's gonna show you a map, exactly where the court's located and directions from where you are to how to get there.
Right.
Okay. Okay, on your ODI, I'm going to give you a $600 fine. Oh, wait a minute. And maybe even more than that, because you had a pretty high test.
155, Your Honor.
Okay, it should be $750, but because you didn't come to court and you have this attitude about it, I'm going to make it $900. That's a lot. There's got to be a penalty for not doing what you're supposed to do.
Right.
Okay, I don't know who we're getting feet over. I think it's a jail. Turn it off. Okay, there we go. Okay, $900 fine, court costs, a 6-month jail sentence, which starts May 26th, I'm sorry, 6-month license suspension, which starts May 27th. I'm going to make it 30 days in jail. And I will suspend 24. So you got 24 days over your head, because you got still more stuff you've got to do. You've got 5 days of community service you have to do. Her hearing date's going to be February 9th for review. So if you don't do what you're ordered to do, don't come to the review hearing, we're going to go through this whole process again, because you'll get another warrant for not showing up, not doing what you're supposed to do. And these things you're ordered to do, they're not going to go away. And you can't get out of them saying, oh, I didn't know what I was supposed to do, or my grandmother died, or whatever. You know, I hear every excuse in the book for not doing what you're ordered to do. It doesn't matter. You're going to go to jail. I don't want you to go to jail. I want you to do the things you're ordered to do. But if you don't do them, that's the only alternative I have. You understand that? Okay.
Okay, yeah, she's,
I saw her say yes, but,
okay.
all right, say again. Do you understand?
Yes, sir.
Okay. You also have to go to a 3-day driving school.
Okay.
I'm getting feedback from that. You might want to turn. You turn it down a little bit. Okay, then on the speed offense, $100 fine. So you'll get out of jail today, and you got a review hearing in February 9th.
Okay.
We're getting feedback.
Yeah.
Okay, that's all.
2 years, level 4
2
probation.
years, level 4 probation.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Charles Martin, case number CRB 23484, A and B. Kenneth Roberts is on deck.
Sir, are you Charles Martin?
Yes.
All right, Mr. Martin, I'm Judge Capper at Lawrence County Municipal Court. Your charges were faxed down to the Sheriff's Office at 10:25 a.m. this morning. Have you received them?
Yes, sir. Yes, sir.
Okay. 23484A is the domestic violence, and the B case is resisting. Before we go over those, I want to tell you about your rights, which you probably already know. You have a right to remain silent. You don't have to say anything. You do make statements. They can be used against you. You have a right to have an attorney, to have one appointed if you can't afford one. You have a right to bail, to make the state prove charges beyond a reasonable doubt. Do you understand those things?
Yes, sir.
Okay, the domestic violence charge alleges that at Rome Township, August 7th, you knowingly caused or tried to cause physical harm to Kimberly Taylor. Do you understand that charge?
Yes.
The second charge is resisting arrest. Same date and time, so as you resisted or interfered with the lawful arrest of yourself. It's a second-degree misdemeanor, maximum penalty 90 days in jail, $750 fine. Do you understand that charge?
Yes.
How do you wish to plead to these two charges?
Not guilty.
Do you want a lawyer appointed to represent you?
I'm going to get my lawyer.
Do you have one already, or are you going to hire one?
Well, I'm going to hire one, sir.
Okay. Is there a protection order requested here?
We've received a statement from the alleged victim that she does not want a protection order.
Kim Taylor?
She came to the office and signed a statement yesterday, so we won't be asking for a protection order.
Okay, you're not ordered to stay away from the complaining party in this case, at her request. And her name is Kim Taylor. So you're allowed to go around her if you wish. I'm not restricting you from that. I'm going to let you, so there should be no objection to no R bond.
No, Your Honor.
I'm going to let you out of jail on a signature bond.
Yes, sir.
So you're going to sign something saying you promise to come to court as ordered, or you'll pay a $1,000 penalty for not showing up.
Yes, sir. Can I ask you a question?
Yes, sir.
Will they have the date here for me, the court date, or will you give that to me?
I'm going to give it to you here. I haven't set one yet, so I'm going to set a date and I'm going to give it to you. So we're going to talk about that. Since there's not a protection order, we can go further out. And how much time do you think you need actually to hire a lawyer?
How long could you give?
I can give you 3 or 4 weeks if you think you need that.
Yeah, probably 4 weeks would probably be there.
Okay, I'm going to go exactly 1 month, September the 11th. Today's the 11th of August. We'll come back on September the 11th for your next hearing. And at the court in Chesapeake, you know where that is?
I think so. It's right there after you pass the flea market, correct?
Yes, the flea market court, right across from the flea market.
Yeah, I always thought that was a library there.
Well, there is a library, but it's just down the road from us. So you're in the right neighborhood. If you get that close, I think you can find it.
Yeah, I find it.
September the 11th at 10 o'clock is your next hearing. Not guilty plea is entered for you. Any questions, sir?
No, sir.
Okay, that's all. Mr. Healy.
Well, Your Honor, there is an indication that maybe alcohol played a part in this, and I'm not trying to prejudge anything, I'm just going on what I've got in my file. If that's the case, and Mr. Martin wants to help to resolve things in a way that might be favorable, more favorable to him, we would suggest that maybe he check into some counseling, maybe some anger counseling as well.
All right, did you hear that, Mr. Martin?
It becomes easy.
Well, the bottom line is the prosecutor would like to see you do some counseling for substance use and anger. So that's what they're kind of going to be looking for. So that's up to you. You can process that information, discuss it with your lawyer.
Okay.
Okay, that's all.
Thank you.
You're welcome.
State of Ohio versus Kenneth R. Roberts, case number CRA 23-470, CRB 23-142. Timothy Watts is on deck.
Your Honor, we are set here for a F4 preliminary hearing, and then on an older case, which is a violation of protection order. I understand the state's going to dismiss the, what?
I'm his mother.
You're his mother?
I'm supposed to be.
Okay.
Is this Kathy, you're Kathy
I'm
Roberts?
Kathy.
You go this side.
Yeah, go
This
back.
side.
Yes. I understand the state's going to possibly dismiss the F4 today, and then we'll, I understand the state didn't have any information on the violation, which has nothing to do with his mother. So it's a completely different case. So I just asked that be reset and be heard on bond.
Okay, so this 23-470, I don't think, no, it had been arraigned. It was set for a preliminary hearing.
We arraigned it on Monday, Your Honor.
Yeah.
And you figured out that he didn't take the
He
drugs?
didn't take them.
You sure?
I'm positive.
Does he live with you?
Yes, he
Does
does.
he treat you okay?
He takes care of me. He cooks for me. I have Alzheimer's and two of my toes cut off. And he's a good son. He treats me good.
So I guess we'll be nolling that case, Your Honor, the 23-470.
Okay, at the state's request, and it sounds like at the victim's, alleged victim or complaining party's urging, 23-470 is dismissed. And then you just want to continue the other case?
Your Honor, the other case, we couldn't find information on it. We don't know what exactly that case is about, so I just asked that be reset. I think he failed to appear on a hearing maybe at one point on that, but I believe he'll appear next time, so I just asked that be reset.
It was a violation of protection order.
It was a violation, but that doesn't have anything to do with his mother. That case doesn't.
We've misplaced the file. We're going to have to figure out where it is, but.
And it was a robbery. The one we're talking about now is 23-142. Is there more?
Yes.
Yes. 23-470 is going to be dismissed. 23-470 is dismissed. Now we're on the 23-142. Doesn't say anything. Yeah, 23-142.
So ask that be reset to another day. He'd be allowed to sign his own bond.
The person involved in this was named Roberts also, though.
It's Mr. Roberts' spouse.
Diana Roberts.
Yeah, and I do have the police report here. And
And on that, the problem was, it looks like he failed to appear.
Yeah, I believe in July.
Well,
He
he failed to appear for the arraignment, April. Then he got arraigned in June and had a hearing July 14th. He failed to appear for that. So I don't know how we're going to get him here without a bond. He doesn't come.
we'd request a bond, Your Honor.
Can he post a bond?
I don't have the money.
I think I'd set the bond before 2,500,
I don't have.
cash or surety.
He can't make a bond, Your Honor. If maybe allow him to sign his own bond and put an ankle monitor on him.
That sounds good.
You don't have it? No.
We don't have an ankle monitor.
Okay, well.
He can't post any bond at all. Zero, zilch, nothing.
Nothing. We don't even have money, Your Honor. I'm not trying to make you feel sorry for me, but we don't even have money to even eat on this, pay our bills.
Well, maybe he just needs to sit in jail then, because
No,
I don't think you get to decide that, man.
my husband just got out of the nursing home and I have to take
Here's the
him
problem, he
back.
doesn't come to court. If I let him out, he's not gonna come back to
Yes,
court.
he will. You got my word. You got my word. I've never been in any trouble.
I've
And
never,
I will
you know
have
what,
him
and
here.
nobody in court has ever promised me something that didn't happen.
I
It would be
will.
the first time, but
I promise you I will bring him myself.
I'll reduce it to $1,000, cash or surety. Can we get a hold of Diana Roberts and see what she wants? You know how to get a hold of her?
If she wants to pursue it.
She wants to pursue it,
She
okay.
wants a divorce.
Now, there would be a way to resolve it today, and I don't know how many days he's been in jail. If we found that out, we might be able to calculate how much
He was
more.
arraigned on August the 7th, so it was sometime before then. Okay, let's say the whole history here. The arraignment date was April 10th. He didn't appear. Warrant was issued. He got arrested and arraigned June 23rd and was given an OR bond and given a hearing and an attorney. Ordered to appear July 14th. Did he appear? No.
No.
He did not appear. No, the warrant was issued. He gets arrested again and is arraigned on August the 7th. Then bond was set at $2,500 cash or surety because he failed to appear twice before. And here we are.
So he's done at least 4 days in jail, probably
say.
more. So if he pled guilty, our recommendation would be 90 days in jail with 80 suspended. So he would finish out 10 days. And then, of course, he would know that he needs to continue to stay away from the complaining party. If he wanted to do that today.
He's not never been around her.
Ma'am, you don't need to say, you're out of order right now. This is between the lawyers.
Your Honor, I'll let him answer right now. Do you want to do that, Mr. Roberts?
I'm not guilty of what it said in that paperwork. I need to get a hold of her.
Okay.
If I did message her, it was
Your Honor.
I messaged her before I was.
Well, hey, Mr. Roberts, let's not go into the details of the case. It's not a trial. So if you don't want to plead guilty, then, Your Honor, we'll just have to reset it.
I'll amend the bond to, I just need some sort of guarantee to get him here because he hasn't demonstrated any inclination to come to court when he has a signature or no bond. Sir, you don't need to say anything else. $1,000 cash or surety will be his bond, and you want to come back pretty quick then?
Yes, Your Honor.
August the 18th.
I love you, Kenny.
And let's try to get the complaint party here that day.
All right. Thank you, Your Honor.
Thank you.
State of Ohio versus Timothy Watts, case number CRA 23485, and Tracy Gill is on deck.
Sir, you're Timothy Watts? Yes. Mr. Watts, I'm Judge Capper, and this hearing is being conducted by teleconference, obviously, but you are appearing in the courtroom, and your image and what you say is all being recorded. So if you admit something, it's going down on the record, it can be used against you. You don't have to say anything. You have a right to have an attorney, to have one appointed if you can't afford one. You have a right to bail and to make the state prove this charge beyond a reasonable doubt. Do you understand those things? You're charged with possession of drugs. It's a felony 5. It's alleged that and this was faxed down to the jail this morning at 10:30. It's alleged that on August the 7th, 2023, you knowingly were in possession of methamphetamine, a Schedule II substance. Possession of that is a felony of the 5th degree, maximum penalty is a year in jail, $2,500 fine. Do you understand this charge? Yes. Do you have the money to hire a lawyer? No. Do you have a job? No. Mr. Smith, I'll appoint you. I've got, you must not live too far from here, Mr. Watts. It says 3rd Street, Chesapeake. Is that correct address for you?
I live right there in front of Chesapeake High School.
Okay. State's position on bond.
Your Honor, the state would not oppose an OR bond if Mr. Watts would be willing to be assessed for treatment for substance abuse and to follow the recommendations.
Did you hear that, Mr. Watts?
Yes.
So the state's saying they would agree to let you out on your signature if you would agree to go get at least assessment and do any treatment that was recommended for you while your case is pending. Is that something you would be interested in?
Yes.
How do you pay for medical services?
I got that part, but the, when you get temporary to,
Say that last thing again. I didn't hear the last thing you said.
I need to get it transferred over here to Ohio.
Okay. So you've been living in Ohio, but you've had a West Virginia medical card before. How long have you lived in Ohio?
How long, months,
Okay. Who can do an assessment? All right. Bethesda's going to do an assessment. Can you do that over the phone? And I'll let your lawyer be involved in that, and then we'll decide if it's going to be inpatient or outpatient or what, and come back and decide on bond.
Be fine.
Case will be recalled.
Are your file, Judge?
Yes. Okay, your lawyer and a treatment counselor is going to call and talk to you, and then we'll have you back to decide what your bond's going to be.
State of Ohio versus Tracy Hill, case number CRB 21643 on a call. And Aaron Atkins is on that.
I'm going to hold off till the very end of their On Aaron Atkins, we're going to wait until the court is almost over to do him. Tracy Hill, this is Mr. Morford's case. How do you wish to proceed, Mr. Morford?
Judge, well, he was missing in action. Supposedly, he went to the Life House and pleaded to the Life House. Did not report to anybody here in Lawrence County where he was during the time period he was out of pocket here. I don't know if he's got any money he can post a bond with. He was in OVP at least for a while, Judge. And then he went, I believe, to the Life House.
Well, I was thinking that I had, it's Rocky Meadows, right? Life House?
Yes.
I was thinking I had his cell phone, but
You did it one time.
I don't think I do. It's not showing up. I was going to just text him. What's the state's position on this?
Your Honor, Mr. Hill has 1, 2, 3, 4, 5, 6, 7 charges pending in Ironton Municipal Court.
Oh, so he's probably not going anywhere anyway.
In 2021, he was charged with a violation of protection order, 2 of them, and a theft, and a resisting, and a criminal trespass, and something else, I don't know what it is, but none of those were resolved. And then recently, he was arraigned on one of them, or all of them, pre-trials on some of them, arraignments, and I wish Jasmine was here because she knows exactly the story. Anyway, when he went into court, the Ironton Municipal Court, on August the 3rd, there was a warrant from this court, but they didn't catch it. So he got out, and then he has committed another violation of protection order on August the 9th.
This year?
Yes, and he was arraigned on that yesterday. He's got a $2,500 cash or surety bond from Ironton Municipal from yesterday on that new charge. And, you know, this is there's just a whole bunch of these violations and various charges, so this has become a very serious situation. I don't, the last 2 years or whatever that apparently nothing has gone on, but now he's come back and causing problems again. So we would ask for a $2,500 cash or surety bond in this case also.
Bond will be $2,500, cash or surety. Set, and what I would suggest, I would like to see the records or some kind of report from Lifehouse if he did do a treatment program there and graduate from it. I need some information from them. And,
Graduated September 5th
of last year?
of last year, yes.
Okay, so when's he supposed to go back? Are you representing the Iron Municipal?
I am not going.
You know when your hearing is in Iron Municipal?
17th.
It's next Thursday is when it is, and the only charges on that was against me was just one, about 2 violations. And there was nothing else, no resisting arrest or anything like that. There was nothing else there.
August 18th then here. I'll set your next hearing for August the 18th in this court, 10 o'clock. The day after, Iron Municipal.
Thank you, Judge.
You're welcome.
State of Ohio recalls Olivia Jackson, case number TRD 194068.
All right, we confirm, Ms. Jackson, that you are valid. Okay, so how do you want to handle this? Let me make a suggestion I would do. Okay, it's good that you got reinstated, but you should have come back to court. I don't want to cause you to lose your license again. What I would be agreeable to do, we'll see if the state objects to it. If you will pay the court costs, I'll just dismiss it. You don't get any record on this. You got to pay the court costs.
I can do that today, actually.
State agreeable with that?
Yes, Your Honor.
All right, see the clerk, pay the court costs, and your case will be dismissed.
Thank you.
Clerk's to the right as you leave.
State of Ohio recalls Bradley Thacker, case number CRB 23330.
Mr. Stratton's case, and this is one that was set for trial.
Yeah, it was set for noon, Your Honor. He was here on time.
So the good news for him is it's going to get dismissed.
Yep.
All right, and I think that was at the request of the complaining parties.
Yes, we consulted with the complaining party, and they agreed that just to let Mr. Thacker know what Ms. Black's feeling was, that maybe this has been a learning experience for him, and that's what because he's a young man, she wanted him to recognize, that he needs to do things the right way. But we are asking for the payment of court costs.
Is that?
Can you pay costs? Yeah, we'll
Okay.
pay costs. Yeah.
All right, see the clerk, and you are getting some grace and mercy today from these folks. So maybe sometimes we don't want justice, we want grace and mercy.
Grace and mercy.
So that's what you're getting.
Thanks, Your Honor. Hey, just go pay costs.
State of Ohio versus Elson Childers, case number TRC 23629, A, B, and C.
It's Mr. Steyer's case set for pretrial.
Your Honor, this matter is an OVI. We were here a week ago, at which time test results were not back, and we were reset to today to see if they had come in.
gonna have to send this to Rob. I'm sorry.
Can we get that today, though?
Yes, I'll try to get it.
Okay, we'll recall it later.
Have a seat, please.
State of Ohio versus Tanya Leonhardt.
Ms. Leonhardt contacted me this morning. She had lost her ride here, but her car broke down. But I asked her to try to be on the video conference. I'm not sure if she's there or not, because I don't know if anyone's on there now.
I don't see her. Oh, yeah, still showing, let me see. She has the video and audio turned off. You have a way of contacting her?
Yeah, I've been texting with her. Is it Tanya?
That's me?
Yes.
Yep, here I am.
Okay, great. Your Honor, obviously she wasn't able to be here, but I asked her to be available on video so that we weren't just without anything at all. But at this time, I'm going to ask for a continuance so that we can get her in here and address the case more effectively than we could by video. But she is here, and we would waive time constraints to accomplish that.
All right, there's Ms.
Going
Leonhardt.
to my vehicle broke.
Okay, so what's going on with the A case? That's concerns me.
Pull up the file again, Your Honor, I'm sorry. I believe we had discussed the possibility that, I discussed the possibility of her dealing with the QRT program, but she's gonna have to be here in person to meet with them to be screened for that, so,
If you can provide me a number, I can call her.
I can get a phone number for you.
QRT program?
Yes.
Want to do that today?
Yes.
Let's let her talk with them and see, I mean, we're a month in, I don't see we've made much progress, I want to get things started. So, do you have a number where you can be reached, Ms. Leonhardt?
Yes, sir, I do. Ready?
Yes.
740-307-0079.
Okay, you're going to be getting a call, take the call, have a discussion, and then we'll have you back by teleconference to decide how we're going to go forward.
Thank you.
You're welcome.
Go ahead and jump off the teleconference so you can take the call.
Okay.
Thank you.
State of Ohio versus Joseph D. Whaley, case number CRB 23-419 and CRB 17-170.
This is a domestic violence. I think my understanding is that the victim has contacted the state.
She wants to drop the protection order, and we'll do a 90-day continuance. Now, here's the thing. Joseph's already, he's got a case in Ironton where he's doing treatment. We want him to do the treatment. And we want to, this is treatment here. Okay.
Well, hold on. Your Honor, I guess the victim contacted the state and asked to have the protection order dropped, but can't be here because she's at work and wasn't allowed to leave. So I don't know if the state's willing to make that motion.
We would be willing to do that today, Your Honor. She's given us a pretty complete report of what's going on.
All right, at the complaint party's request, the protection order in 23-419 is dropped.
In that case then, Your Honor, I think the state's willing to do a 90-day continuance with dismissal upon payment of court costs, and there's no further problem. And he is, I guess he's in treatment at PATH. He's going to continue that while this is ongoing as well. And we have a matter in Ironton Municipal Court that's going to be handled separately, but it's going to also tie into what we're doing here. So at this time, we're willing to do that. Hang on Talk to me, not to him.
I was just trying to tell him about the job I just got.
Okay. All right, that's fine then. I just want to make sure you didn't say something that could hurt the case.
I'm not a rookie.
I know. But at any rate, Your Honor, so we would be willing to do that. We would waive time constraints to accomplish the same.
Okay, and just as a reminder, he has case number 17170 that he owes on, and I think some of that's restitution that's owed, and 17133. There's restitution on that. Now, he did make some payments on that. A restitution and a fine. So those have to be done also.
Right.
All right, so when do you want to come back?
Well, the state suggested 9-day continuance. We're willing to go along with that. I don't know if you want to come back quicker because of
Come
the
back, he's going to have reviews. on the other cases.
Right, so I don't know if you want to come back sooner and just,
Let's make it a month.
okay.
Get to work on those old cases, get them taken care of. Pre-trial on this case and reviews September the 11th.
Can I ask real quick, he started a job. Is Monday or Friday better for you on your job?
I haven't started it yet. I actually just got the confirmation today that I'll be starting at Marathon Barge Company on Wednesday in Ashland, Kentucky.
Now, is this going to be something where you're going to be gone for long periods?
Evidently, but
Well-
I can have that worked around. The guys, it's through my pastor at church. It's a buddy of his that actually has the boat. He's gonna be our captain
Okay, well,
anyway.
we'll try to work with you, you just need to communicate with your.
Yeah, just make sure you
That's
get
all.
with me and we'll make all that work. We want you working. That's how you're going to get that stuff paid off.
September, as of now, September 11th is the next hearing.
And Your Honor, I'm actually not available the 11th.
Okay.
I'm available the 8th or the 15th. No, actually, I'm not available 15th either. That week I'm gone, but I am available the 8th, 18th, and
Let's make it the
22nd.
8th, September the 8th.
Thank you. 10.
Central
call
Law
it 10.
versus Gavin Montgomery.
Thank you.
Case number TRC 23937.
Yeah, I'll come get it.
We can do those anytime. All right, this is Mr. Steyer's case set for pre-trial.
Your Honor, discovery's been exchanged, but has been provided by the state, including the video in this matter. I have, the videos are provided like by a download now. I put it onto a memory stick and gave it to him this morning. So I'm going to ask for a brief continuance to have it, give me an opportunity to take a look at the discovery with me, and then we'll come back and go forward from there.
Okay.
So, and since this is, you know, a date that's convenient to the court.
All right.
We'll waive time constraints for that purpose.
Well, I'll just set one for you, September the 8th, and that's a good date.
I'm here that day.
September 8th.
Write that down.
Pre-trial, 10 o'clock.
State of Ohio recalls Bill and Biden, case number CRA 22473 and others, and State of Ohio versus Jeremy A. McMillan, case number TRC 22769 and others.
All right, so council's had a chance to talk with their clients, and you've seen the reports, and
I'm looking at the report now, Judge, but I have spoken with Jeremy earlier today, yes.
Yes, same here, Judge.
and do we have any explanations?
Judge, I had a rather lengthy explanation for Mr. McMillan. It'd be probably better if he told you because it took quite a while, and I don't want to misspeak. No, that's because of the incident. That's the incident. You just explain this incident. This is okay, but you need to explain what you told me outside. What happened at Speedway? Just the way it happened, B.
Well, and if it's going to be that you're lying about something, I'd rather it be an admission than an excuse.
I'm just going to,
The way I explained it, it sounds like justifying what I did, but I know what I did was wrong. A couple of my brothers of the house went into a store and was buying Red Bulls, and I was in the parking lot. And one of them come to me, said they was in trouble. I walked in there, I seen a manager yelling at the cars declined, they're trying to steal it, and this and that. All I seen was people going to jail. I said, I'll take care of it. We paid for everything. And we didn't leave until he said, get off the property and not come back. And we came back to find out the cup didn't get paid for. And I told him I would take care of it.
I think there's more to it. Didn't you tell him that, one, is what's been explained to me, you came in and told him that you were in charge? That you tried to represent that you were an employee of the treatment facility? Is that correct?
Tell them what you did.
Yes, sir.
And that you told them the wrong facility. You told them you were from Southern Hope.
Yes, sir.
That I didn't know.
Yes, sir.
Yeah, you tried to throw them off the track.
Yeah.
I'm from Southern Hope, we're from Southern Hope.
That's
I'm in charge here, I'm one of the counselors.
I didn't do it that way. I was presented and I answered yes to that question. I didn't go in there flashing, I answered yes to that question.
They asked you if you were from Southern Hope?
No, they asked me if I was in charge, and
well, then you lied and said yes you were.
Yeah, that's what I did.
This is totally floors me. It totally floors me.
Me myself, Your Honor.
Because you are on the precipice of going to not jail, prison for years and years and years. You were on the way, and I had to go pull you out from Cabell County by me going and talking to a judge on your behalf, and then you do this? I thought you were a better man than this. I thought you were wanting to be an honest man, a truthful man, a man that was going to be a credit to the community. And here you pull this crap?
I had no excuse.
You're still a criminal mind. It's a criminal mind. You go in there and you see something wrong and say, well, if I have to lie, steal, and cheat, that's what I'm going to do. Instead of going in and being honest from the very beginning and saying, sir, it's fine for you to offer to pay for it, no problem with that, but you going and representing that you're in charge, that you're an employee of the treatment facility, and not even the same facility. You try to tell me you're from Southern Hope, not Bethesda. That is totally a lie and dishonest and deceitful. Am I wrong?
No, sir, you're 100% right. I was reacting to what was told at me.
Well, you reacted totally wrong.
Yes, sir, I was wrong.
Rather your first instinct being to tell the truth, your first instinct was, well, I'm going to try to lie our way out of this.
That's putting other people's interests in front of mine. I found something else I would do if we truly need to work on.
That wasn't the problem. I don't mind you helping Dylan, but you help him by telling the truth. You don't help him by going in and telling a lie on his behalf to try to help him get out of what he did. You're really an accessory to this. I mean, it's not the crime of the century, but what it really upsets me about both of you, part of getting recovery is going a different way than you have been. Being honest, being truthful, being forthright. And neither one of you were any of that. Now, Dylan, let's hear. You keep coming back. You keep coming back with this crap. I think I told you last time you better not even spit on the sidewalk. And here you are, and it was in Speedway, right?
Yes.
And you took an energy drink, which you're not allowed to have in the treatment facility. So two things are wrong. One, you took an energy drink, which you're not supposed to have, and you know that's a violation of rules, right? And you tried to disguise it by pouring it into one of their paper cups and present it at the cash register like it was a fountain drink, and pay for a fountain drink rather than an energy drink. Is that right?
That wasn't the plan. It was not. It was the whole purpose.
Isn't that what happened? Look, man,
that is what happened.
You better get honest with me right now.
Yes.
Didn't you throw away the can?
I I did.
So you were trying to pay less and get it back in the facility when you knew you weren't supposed to?
I wasn't trying to get away with the Red Bulls. I've got plenty of money. That was not the problem at all. It was just the purpose of me knowing if I would have come up to the register with a bunch of Red Bulls on the counter, it would have just, they could have seen it outside and then I wouldn't have been able to have my Red Bull. The whole purpose of the cup thing was just to get it by Bethesda, not the purpose of me stealing it. That was not a problem.
Well, did you go up there and say, hey, I poured Red Bull into these cups?
I didn't even get to that chance. I didn't make it that far to tell him, like, as soon as he seen me cracking them open, it was all hell.
And throwing them what? Throwing away the cans?
John Dewey was the one that threw it.
Okay. I mean, you both, you got a felony.
I'm scared to death.
Well, you should be. You don't act like you're scared to death. You weren't acting like you were scared to death at the Speedway.
I'm terrified. Jail's not a place for me. It's not.
Well, that's where you're going. For at least the weekend. There has to be consequences for doing stuff like this. And, I mean, that's the easy thing. I mean, if I called West Virginia, his probation officer in West Virginia and told him what he did, they'd be coming getting him, he'd be going to prison because of you. And you're on that cusp of going to prison. You got a felony pending. You better start acting like you're afraid of going to prison. You don't act, you act like you can skirt the rules. I mean, that's what you were here before. You basically caused you were involved in an insurrection basically at the treatment facility before, right? I mean, violation of the rules, we're going to go someplace else, we don't like what's going on here. Okay, I'm commanding both of them into jail for the weekend, and we'll deal with it Monday, whether you're going to stay longer or not.
I'm here Monday, Judge.
Thank you, Judge.
Your Honor, Bethesda would like to publicly apologize to Southern Hope for the behaviors of our clients. We would never want to throw another treatment facility under the bus and want the community to know that we still work together as a team. So we just...
All right, thank you for that. I'll see both of these gentlemen Monday.
Thank you, Your Honor.
State of Ohio versus Sierra Helms, case number CRB 23418. Sierra Helms.
This is Mr. Smith's case set for pretrial.
Could we recall this, Your Honor?
Yeah.
I have no problem with that, Judge.
This case will be recalled later in the docket.
State of Ohio versus Susanna Ness, case number TRD 2261A and B, CRB 2098A and B. Susanna Ness.
I saw this on the docket, but it's an older case, and I saw it set for pretrial today, but I'm a little confused on, I thought maybe she got arrested.
Well, I think she failed to appear July 10th, but then she came in, I don't know if she got arrested, but she was arraigned August 4th, and I set another hearing for today for pretrial.
Okay, well, I have had no contact with
She
her.
took a screen on August the 4th. I probably should not have let her go,
okay.
because she was dirty. Although
didn't-
she claimed that she had a prescription for one thing.
She did not call my office, Judge. I haven't spoken with her.
Okay, there'll be a warrant.
I'll see if I can
in
find her.
7 days if she hasn't appeared.
I'll try to find her.
Okay.
When are they going to be released from jail?
I don't know.
You're going to just leave them in there? Okay.
They're coming back before me Monday.
On Monday, okay, that's what we're going to do.
Christopher Blevins, did he leave? Because I just got a text from OVP, they can't find him.
We called OVP, Your Honor, just when he came to the counter afterwards, and they,
I guess they came here to pick him up and they can't find him.
well, he asked us to call.
State of Ohio versus Thomas Jarvis, case number TRC 23972, A and B.
All right, Mr. Jarvis, do you have an attorney?
I do not.
Why not?
It's not something I can afford at the moment.
Well, how are you going to proceed?
I guess I'm going to represent myself. I don't have much of an option.
Okay. Do you want to be considered for a court-appointed attorney?
You won't appoint me one, sir. I make too much.
Okay. Well, I guess the state can tell you, if you represent yourself, what they would ask for. Thomas Jarvis. It looks like it's a second offense with a breath test of 12. What's the state looking for Mr. Jarvis?
Well, it's a second offense, and there are mandatory minimums of at least 10 days in jail, or if the court deemed it appropriate, 5 days in jail and 18 days of electronic monitoring, a year license suspension, a fine to be determined by the court, and community service perhaps. So I guess that would be our recommendation. And there are times, in situations like this, where an individual comes forward and says, I believe I've got a problem, I've got an alcohol problem or drug problem, and I'd like to go to treatment. In that case, sometimes we offer, if they plead guilty, to let them go to treatment and then see how that pans out. Actually, the prior was in 22, so that might be indicative of some things that maybe Mr. Jarvis would like to address. Certainly would change our outlook on the disposition if he did that and was successful.
Okay, Mr. Jarvis, is that anything you're interested in?
Yes, I could possibly look into doing the counseling. My only issue is that if I do have to take off work for jail, then I'm probably going to lose my job.
Okay.
And I do have a really good job, and it's not something that I can really get back into if I lose it.
Where do you work?
I do bridge work. I'm a union carpenter. I build bridges for a living. I'm in Point Pleasant right now. I work in Huntington sometimes, and we have another job that just opened up in Rush, Kentucky.
Okay, well, here's what I'll do. I'll give you another pretrial, a chance to talk to your employer, and, this is really important. I know you say you can't afford it, but this is serious business, so maybe you need to get together the money to hire a lawyer. That's what I would recommend. But if you can't, you're going to represent yourself. Probably at the next pretrial, I'm going to set up for a trial if it's not resolved, so.
Because like I said, I wouldn't be opposed to looking into the counseling.
Okay, but, I mean, that's not all you're going to get.
I understand, yes, sir.
And what the state is, as I understand, saying if you pled guilty, they would let you go to counseling for a while and see how you did, and then delay the sentencing until we get reports back on the counseling, and then try to work with you and, give you some credit for the counseling if that's the way it goes. But they would take a guilty plea first. And probably would be some jail time involved, so maybe you need to discuss that with your employer.
Okay.
All right, let's set September the 11th as a pretrial, and probably set a trial date then if it's not resolved, if there's not a plan to resolve it at that point. Any questions, Mr. Jarvis?
What time on the
10
11th?
o'clock.
10 o'clock.
10 o'clock on September 11th.
Thank you, sir.
You're welcome.
And, Your Honor, if there's counseling people still here, maybe he'd want to go ahead and talk to them.
Yeah, there's several counselors here if you want to talk to them.
State of Ohio versus Christopher R. Hale, case number CRA 23424, CRA 2487, CRA 1964.
Yes, sir.
All right, so this is an arraignment and poll charges. And you are Christopher R. Hale?
Yes, sir.
Okay, Mr. Hale, you've got a new charge, tampering with evidence. Case number 23424. You have a right to remain silent. You don't have to say anything. If you do, it can be used against you. If you admit something, you have a right to have an attorney, to have one appointed if you can't afford one, to have bail, to make the state prove charges beyond a reasonable doubt. You understand those things?
Yes, sir.
The new charge is a felony of the third degree. It alleges that on July 3rd of 2023 in Union Township, knowing that there was an official proceeding or investigation in place, that you did alter or conceal a thing to impair its availability as evidence in that proceeding. That carries a maximum penalty of 5 years in jail and a $10,000 fine. Do you understand the charge?
What, and is this is this the ankle monitor?
Yes, sir.
Oh, okay, I understand now. I wasn't sure. I didn't cut it off. I returned, I got a new, they changed me, but yes,
Well,
yes, sir, I understand.
I mean, this is not the trial, so I can't just say, okay, we're throwing it out.
Oh, yes, sir.
This is just a hearing to make sure you understand what you're charged with. They may not be able to prove it, but that's what they're charging you with. Do you understand that?
Yeah, yes, sir.
Do you have the money to hire a lawyer?
No, sir, I'm in treatment.
You're still at RRS?
Yes, sir.
Okay.
I have a new monitor on that they,
I'll appoint Mr. Steyer to represent you. Probably, why don't we do this, probably need to take a break, let you talk with him, read this report, it's kind of lengthy, then come back and decide what we're going to do on bond.
That'd be fine. Captain, just 1 second. I'm taking a look at the state's file.
Your Honor, it's my understanding that what happened was he was wearing an ankle monitor that was issued out of common pleas court, and it ran down, and he's supposed to keep it charged up. They placed a new monitor on him since then, and he's in counseling. So I'm just kind of reading between the lines that they already understand what happened, and they haven't put him in
Well, I don't think
incarceration.
Mr. Steyer does.
Well, no, I just took a look at that.
And it's not the greatest report either.
And I recognize that. I saw enough to see that it wasn't what we'd be striving for, but, yeah, we can either just set this back relatively quickly, or we can come back in a few minutes and give me time to talk to him, whichever's better for the board.
Why don't you go talk with him, and then we'll come back and decide the way forward.
And so, did I hear a theft mentioned? Because all I'm seeing is the tampering.
He's got some old cases.
Oh, old matter. Okay, that's fine then, you're right.
Theft offense is 2487.
But these are
Both
post-conviction.
theft offenses and his priors.
Those are post-conviction though?
Yes.
Okay, just wanted to make sure I wasn't missing something that was pending now.
Yes.
Your Honor, is he in treatment on something from this court?
Yes. That is old.
Yes, sir.
All right, thank you.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Stephen Stapleton Jr., case number CRB 23-428.
Okay, this is set for a sentencing today, and Mr. Stapleton had entered a guilty plea before, and I delayed the sentencing because I wanted to hear from the complaining party their input on this, which is John Smith. Is John Smith present today?
John Smith? No,
Your Honor, the victim is Gary Fetty. We made a mistake on the complaint, and we have spoken with Mr. Fetty.
All right.
And so we've moved to amend that. I thought we had done that already.
Okay, and it looks like, I'm reading the rest of the statement, it looks like Mr. Fetty really didn't want to cooperate or participate in the charging process.
He has, he would like for Mr. Stapleton to take part in anger management counseling. He did not want a protection order, and he just felt that jail punishment was not the answer for this young fella. And so what we would propose is a continuance and allow him to do that if he would be agreeable.
Do you understand what the prosecutor's saying? They want you to go to some counseling, and then they're not asking for jail if you do that.
Yes, Your Honor, I do.
And you're agreeable with that?
Yes, Your Honor.
Do you have a medical card?
Not on me right now.
Well, I mean, how do you pay for medical service? You have a Ohio medical card?
Oh, yes.
Okay, well, that will get you treatment. And you live in South Point?
No, Your Honor.
Where do you live?
I live with my aunt out in Pedro.
In Pedro? Okay. Well, so probably Ironton's the closest place for you to go maybe for some counseling? Are you getting any kind of medical services now? Do you have a family doctor or someone that you see for medical care now?
I do have a mental health specialist, psychiatrist in there, Shawnee.
Okay, at Shawnee. The only problem with Shawnee is I can't hardly ever get a report from them. You know, if I ask them for a report, they're very uncooperative as far as giving reports. Have you been going there for a while to Shawnee?
Yes, Your Honor.
And are you happy going there?
Yes.
You like your counselor? Think they help you?
Oh, he helps me a lot.
Okay. Well, we'll try to work with them then. I'm going to order that you continue to go to Shawnee, and I want you to go to the probation office and sign a release. And we'll send it to them and ask them to send us a report. I just want to make sure you're dealing with this so there's not a problem that you get charged again down the road. So it sounds like, from reading between the lines with the state, if you convince us of that, then you're going to take care of this and get the right treatment, that the state would dismiss the charge down the road. And I'm assuming you'd like that, to have the charge dismissed.
Yes, Your Honor.
Okay. Let's come back in a month. go to the probation office, sign a release, we'll send it to Shawnee. Hopefully they'll send us a report saying how you're doing. And if the state's convinced that this is going to take care of things, at some point they'll dismiss the charge, I believe. Do you have any questions?
No, Your Honor.
Okay.
We'll need Mr. Stapleton to sign a waiver, time waiver.
I think what I'm going to do, Mr. Morford, under these circumstances, I think it'd be appropriate to appoint you to represent Mr. Stapleton. He didn't ask for one. He pled guilty at the arraignment.
Oh, that's
domestic, but
We don't need a time waiver.
I don't know if you were listening in, but I think this is someone that knows him or family member. They just wanted to see him get some counseling. He's already going to Shawnee. We just need some reports to make sure they're dealing with the issue and then likely dismiss the case. But I think under the circumstances, he probably needs counsel.
I'll see if I can't gather the records and the reports for the court judge.
Yeah, getting records from them is always a challenge, though.
Well, you know, there's always a subpoena.
Yes, hopefully they come to that. All right. And you're, I think, available. I think I've already appointed you on September 11th for some other things. Okay, Mr. Morford's going to be your lawyer. He'll help you with, maybe he can get a record out of Shawnee. Okay, I think it.
Thank you.
You're welcome.
State of Ohio versus Travis R. Valera, case number CRB 23425.
Okay, Mr. Valero, you had told me you were going to hire a lawyer, is that right?
Yes.
Have you been able to do that?
First couple weeks I was not able to, but I have counsel now and I'm meeting with him Tuesday. I was wondering.
Who's your lawyer going to be?
JT Holt.
Okay, I'll put him down as your attorney. Did he give you any dates when he was available to come by?
No, I gotta sit down and meet with him Tuesday.
Okay, I'm going to continue this then to September the 11th, and if you tell him that's the date I set it for, if that's not a good date, he needs to request a continuance.
All right, thank you.
September 11th at 10 o'clock, at your request.
Thank you, Judge.
You're welcome.
State of Ohio versus David Ketchner, case number TRC 221615 A and B.
All right, this is Mr. Finley's case. It's set today for a sentencing.
Yeah, that's fine.
Judge, can we approach? I've got
Yes.
additional documents with it.
I did. Okay. They have to test twice a day. Breathe in or something. Breathe your mouth. Okay. he's not on there.
Yeah, he's on.
Oh, he is. Spend it back here. All right, Mr. Keckner is present. Okay, we can do it. All right, so is there a motion on behalf of the state?
Your Honor, if it please the court, if we're proceeding to sentencing today, which I believe we are, what we ask of Mr. Keckner back at the time that he pled guilty, which has now been some time ago, in fact, I don't even have a date on it, but he pledged that he would, well, it was back in February of this year, that he was going to maintain his sobriety and show us the efforts that he's made through reports from his doctor and the sober link that he has been using and the other things that he's been doing by going to meetings and things of that nature in order to stay sober. He's expressed to the court previously his motivation to do that has to do with his family life and his career and things of that nature. And we wanted him to do that and show record of compliance and sobriety so that we could agree then to recommend that there be a suspended jail sentence as part of his disposition in this case, but there would need to be no jail time imposed at this time. We also believe that the amount of counseling and other things he's done is far in excess of what the 3-day driving school would do for him, and so we would not oppose that if those efforts would stand in lieu of the 3-day driving school. And we take no position on the fine, court costs, or community service, or excuse me, driver's license suspension 1 year. We have no opposition to occupational driving privileges. And what did I say? Court costs? Yeah, court costs.
All right, Mr. Finley.
The only thing I would add, Judge, is that he's been under a administrative license suspension since June 4th of 2022, so we'd ask for credit for that. I think statutorily that's required, so just so the court's aware of when this actual date of offense was. But I have provided the court, as you know, periodically throughout since the plea in February with multiple efforts, multiple things that Mr. Keckner's been doing, which includes through medical professionals, psychological professionals, various treatment, plus the daily monitoring that he's subject to. And I think I provided to the court that he just received his 1 year from SoberLink of complete sobriety. So that's that demonstrates that he's not drinking at all, Judge, at least in the last 12 months plus. So we'd ask the court to follow the state's recommendation.
All right, Mr. Keckner is appearing by teleconference. Mr. Keckner, do you have any statement or explanation you want to make before I finalize the sentence? You're not required to, but you're welcome to if you wish.
I have no statement to make, sir.
All right. Okay, I'll allow one thing I want you to understand, Mr. Keckner, if I have already accepted your plea, but if I go ahead and finalize it, if you were to get another one of these, it depends on the law of the state where what would happen, it could jump up to a much more stringent required penalty because of this going on your record. You understand that, sir?
I do, sir.
Okay. All right. I'll accept there was a guilty plea entered. I'll accept that. And as a first, it's going to be treated as a first. $1,000 fine. there was a refusal, and that's usually my policy on that anyway, to do a $1,000 fine on a refusal. There'll be a 1-year license suspension, and I'll allow it to start it on June the 4th of last year, so it's completed at this point. I'll do a 30-day jail sentence, and I'll suspend 30 days. His review hearing will be February the 9th of '24. At 9 a.m. I will require 40 hours of community service. I'm going to do a little more than a typical first. 40 hours of community service. Since he does not live in this area, he can do that at any charitable organization, a legitimate charitable organization, that you show proof that you volunteered 40 hours with. And submit proof of that to the probation. I'm not going to require, he has done quite a bit of counseling, so no driver intervention program. The counseling was in lieu of that. Now, what about, he was charged with a license issue also. What?
I believe that was dismissed at plea, Judge, if I recall. That was our intent.
That was the B case.
Yeah. Should be.
Remind me about that, Judge.
That was where he had the suspension from his wife, California. I think that was part of our deal. I think he dismissed it.
I believe we did dismiss that, Your Honor.
All right, the B case is dismissed. So, Mr. Keckner, I asked for you to call in and talk to the probation officer, Mr. Major, and he can send you the documents, or Mr. Finley can get them and send them to you. There'll be a judgment entry that'll have everything I just told you on it, about your requirements, and the probation officer will be your contact person with the court. If you finish everything by February 9th, you don't have to appear. If you have not finished things, you have to appear and explain why you couldn't get things completed that you were ordered to do. Do you have any questions, sir?
No, I understand. Thank you very much, Your Honor.
Okay, that concludes this hearing.
Thank you, Judge.
You're welcome.
State of Ohio versus Jonathan M. Canterbury, case number CRB 22-213. This is Mr. Cremines' case.
This is expungement.
Your Honor, this is a sealing of records of dismissal. State hasn't filed any objection. After speaking with Mr. Heald, he hasn't objected and in fact signed an entry. So if the court's inclined to grant it, may I approach?
Yes.
Thank you, Your Honor.
You're welcome. You'll give that to the clerk?
I'll take it for filing.
Okay, preliminary hearings?
State of Ohio versus Caleb Langdon, case number CRA 23332, CRB 23333, TRD 23672, A, B, C, and D. This is just a mortgage case.
May I approach, Your Honor?
Yes. And this is one QRT had expressed an interest in.
Yes, Your Honor. Mr. Morford asked me to take a look at his file, and I have, and I'd like the chance to speak with him, see if he would like to join.
Okay, you want to do that today then? Or?
Yes.
Okay. Recall it afterwards?
Yes.
All right. We'll recall this after he's been evaluated by QRT.
Thank you, Judge.
You're welcome.
State of Ohio versus Joseph E. Edens, case number TRC 23-910 A and D and CRA 23409.
Mr. Edens was RRG inpatient. I think he went to.
Yes, he went to, is it, he went out to Glenville. Glenville.
Right.
Sorry, I got Mr. King here today, and it was a different, okay.
So he's still there? doing
Yes,
well?
yes. Thank you.
Come back in another month?
Yes, Your Honor.
September 11th?
That's fine.
He'll still probably be there, right? This is a check to make sure he is doing well. September 11th, say 10 o'clock, but it'll be after that before we get to it. That morning, September 11th.
State of Ohio versus Shandon Pringle, case number CRB 2189, CRA 22563, CRB 22564.
Shannon Pringle is here in person and has a good screen, very good. And she's at Restoring Hope. And I've got some results. This looks like the screenings that were done at the facility. They found Christopher Blood.
So I believe you have screens from the last time we were here, Your Honor. Whether it's a...
What's going on now? That's what I want to know. How's she been doing since we changed? She's at a different facility.
Since July 7th, when she came to Restoring Hope, she's been attending her groups. She's active in her case management. She's very active in her individual counseling. She completes her chores. She gets along with her peers. She starts a job on Monday at First Stop in Marathon in Wheelersburg. She has completed her CDCA. She's turning it in on the 14th. She sees her son every weekend with the exception of this past weekend. The screen that she had here at her last appearance, that was an instant cut, but once we got her back to the facility, we did a send-off, and that came back negative. And she's been negative on everything that we send off.
It's all good. Very good.
I guess at this point, just come back again and let her continue with her treatment. Sounds like she's working hard on it now.
Yeah, so what's the next step? Where are things, getting a job, that's all good, and then What's the long-range plan?
I actually had a question, because the next thing I want to work on is getting my license back. And because it was from a DUI back in 2018, that was in Greenup County.
Well, any suspension you have from that should be up by now. But
Well,
there's probably things you have to do to get reinstated.
Yeah.
It doesn't automatically reinstate.
They want me to do the 3-day DUI class, and the only place that I knew around here that did that was Spectrum, and Spectrum's no longer open, I don't think.
Yeah,
So-
there's one in Portsmouth.
Yeah, that's,
Mr. Major has their information if you want to get that,
okay.
the driver intervention program. So Kentucky's requiring you to go to the 3-day program? Okay.
I was told when I was at Bethesda that some of the judges in Ohio would take your 6-month treatment program as the DUI thing, because it's way more intense than a 3-day, but.
I can do that, but I don't have any power over Kentucky.
Yeah.
You're going to have to do what they want you to do.
Yeah, they want me to continue with the 3-day class, so I gotta get that done.
They're the ones that got the hold on your license, so if you want to, you got to do what they want.
Yes, sir.
And the states have entered into what's called interstate compact. So if Kentucky tells Ohio, suspender, they honor each other's suspension. So that's why you got to do what Kentucky says, even though you don't live there. Okay, so another month?
Yes, Your Honor.
September 11th? You're here that day anyway, I think.
Yes.
The 10th.
September 11th. It's the next year. Okay, good job. That's a good report.
Thank you.
Good luck with your job.
Yeah, so tomorrow.
Thank you, Your Honor.
You're welcome.
State of Ohio recalls Sierra Helms, case number CRB 23-418.
Mr. Smith's case, pretrial.
It is, Judge. We were talking about some timing issues. This allegedly happened back end of June, but she was not summoned until the 3rd of this August. She was here last week from arraignment. I did file discovery, which would give the state a little bit more time. I don't know if it's been answered. I've not checked my email today, but I know it was filed and she was arraigned. We are going to set this for trial. Jasmine has spoken with one or two victims is okay to nominate, the other one wants to go forward, so I think we're just set with getting a trial date ASAP.
Okay, you have some times?
Any Friday in August, then I'm out the first 2 weeks of September. So I think it has to be August, just given it's an M4.
Your Honor, Ms. Helms has a driving under suspension charge that's set for hearing on August the 18th, if that helps.
Okay.
Is that in front of Judge Hall?
Oh, I don't.
That's a Friday.
Oh.
That's next Friday.
I didn't.
August the 18th?
Yeah, I didn't. I just was aware of the M4. Maybe I
Oh,
see
maybe you're
that.
not, are you representing her on that, or?
You represent
Let's
yourself?
look it up. Let's see.
If it's a jail
Sierra
offense, or it might just be an unclassified misdemeanor, or...
Well, it shouldn't be on a Friday if that's...
Yeah, that's why I was asking if it was Judge Hall, so I'm not...
CIA-RRA.
I'm just not familiar with that.
CIA-RRA. Yeah, it's set for a sentencing, it looks like, August the 18th.
She said that, was this judge or different judge? Gave you time to get your license restored or reinstated?
Yeah.
Have you done that?
No, I have an appointment. I couldn't get in until 2 days before me.
Sounds like she's still working, Judge, on doing that.
Well, do you want to continue both then to a different day?
If we could, Judge, because I don't mind helping her with that since I'm doing this. If it's on the same day, it's not any more work for me to help her with that.
When do you want to come back?
I could do any Friday in August, and then I'm...
You can't do the 28th, the Monday?
Let me double check. I just had a couple trials go out. She's in nursing school on Mondays, so that's
Okay.
why I'm thinking of
Friday, the 25th could work.
Yes, sir. I'm here that day anyway.
So you want to set this for trial and the other for a pretrial?
Pre-trial, yes. In the meantime, she's going to try to get that issue taken care of with her license. Right?
All right, so that case, that 22-27-11, I'm changing it for a pretrial on that day. Now, I'll set this one for a trial. at
Could you do noon on both, Judge?
We can do noon on both.
Okay, yeah.
August 25th,
At noon, that's a fine.
noon for trial on
And when they get
this,
this
pre-trial on the
discovery
other.
back to me, I'll reach the office, we'll look at it. Okay. I'm straight.
Now, Mr. Smith had made some indication about the speedy trial, but at this
File for
point,
discovery, though, I think.
yeah.
I did file for discovery with the arraignment last
So
week.
we don't have a speedy trial.
No, there's not an issue now. I realized that with my file, I did file, so that tolls the time. They've not answered it yet, so they're still within time.
And that'll be answered before the trial.
We will
I
get
hope-
that
I
done.
would hope so. It's an import trespass.
State of Ohio versus Caleb Langdon on a recall, case number TRD 2367 for ABC and D, CRA 23332, and CRB 23333.
And this is recall after evaluation by QRT.
Yes, Your Honor. He decided to take part, so he went ahead and signed terms and conditions.
Okay.
Is he good?
Yeah, I've been doing great.
And that'll be, you're gonna meet with him once a week, or how's that gonna work out?
At your request, we can do it once a week, but typically we ask once a month.
Oh, okay. Well, I don't think it's necessary, but why don't we do this then? I'll go further out. I'm just gonna keep it on my docket, but I don't need to see him. I've been seeing him about every month, but I can go longer since you're gonna be following him. When's his completion date?
Oh, he's still a good ways off, probably
Okay.
about 3.5 more months.
Okay. Well, let's go mid-October for him then. We don't need to see him for a while. October 20th? October 20th will be the next hearing here in this court at 10 o'clock.
Thank you, Your Honor.
Thank you.
State of Ohio recalls Elson Childers, case number TRC 23629, A, B, and C.
Mr. Stiers' case set for pre-trial.
Do you have a response?
Findings entered, but not yet available.
And that was, I think it's what it said last week.
I believe that was.
I don't know what that means.
It seems as if they're entered, that should make them available, but
When's the time up on this case? Let's see, the charge was filed May 27th.
there was a let's see.
There's not been discovery.
Honestly, I left the file on my kitchen table because it was one that I was looking at, so I don't know if there's been time waivers. If it was May 20th,
August 25th, according to Google, which I trust,
yeah,
all my soul.
yeah, so it's coming right up. So if we don't have it soon, obviously, we won't be able to use it.
You can.
No, I know, but we'll just have to see if we get the results.
Well, do you want to set it for a trial or another pre-trial? How do you want to proceed? August 25th looks like the absolute last day.
Leave that to the state's discretion.
Well, this is the,
You guys got 2 weeks.
yeah, so I would say if we had a pretrial a week from today, and if Mr. Elson, we wouldn't care if he didn't have to appear on that day, but we should have the results by then. And if Mr. Steyer's going to be here.
A week from today, I believe I'm here. Let me make certain of that. I am here that day.
Okay. I will continue it for a week to the 18th.
Thank you.
You're welcome.
Yeah, write that down.
It really the entered but not available makes no sense in this electronic age. Once they've entered it, it should be.
Well,
It's not like you've got a scrivener now, it's going through and making these entries in logbooks. And somebody's got to get the logbook out and pull it.
and entered might not mean what we think it means either. It might mean that it's entered into their system. But this would be kind of a delay compared to, they've been a little bit quicker recently, well within 90 days.
My understanding is that the employees are pretty quickly lured away by higher salaries, and that they kind of get, once they get someone who gets things up to speed, that person gets recruited, headhunted. So
It's an in-demand skill, urine testing.
Could be.
State of Ohio versus Tanya Lamhart.
Your Honor, someone came and picked her up and took her to pick her son up. She just texted me, said she's in a car on a portion of 93 where she's not going to have service for about 15 minutes. So I have a couple more cases. I would ask if we could just push this down the docket a little bit. I apologize.
You tried to call and couldn't get her?
I think they spoke.
Oh, you did talk.
We did speak. She signed up and agreed over the phone, and we have our first scheduled check-in in person next Thursday.
I'm okay with going ahead if you are without.
Yeah, in that case, just get a new date and come back and, that'd be fine.
And when will you be meeting with her then?
Next Thursday.
Okay. So another month?
That seems reasonable to me, and we'll waive time constraints to accomplish that. Again, the 8th rather than an actual month, because unavailability on the week of the 11th or the 15th.
Okay, September the 8th will be the next hearing for pre-trial 10 o'clock.
Thank you.
You're welcome. You'll make sure she knows that.
I will. She's been keeping in touch with me all day.
State of Ohio recalls Christopher R. Hale, case number CRA 23424, CRB 2487, CRB 1964.
And Mr. Steyer was appointed on the new case. He's had a chance to talk with Mr. Hale. And now we're going to talk about how we go forward on that, the old cases, and what to do about bond and those sorts of things.
Your Honor, he has an ankle monitor on. I assume that is in connection to the older cases, which
Well, that's the basis of the new charge.
Right, but I mean, I assume that it's in, it was, so what I would ask is just for an OR bond, since we already have an ankle monitor on him on this matter, and he's in inpatient treatment. I've spoken to him and explained that I don't know what the state's ultimate position on this charge is going to be or how we're going to deal with it, but at least to start with, the better he does in treatment, the better my chance of convincing the state to keep this matter here and deal with it on this level rather than through the grand jury. So I've made that explanation to him. I think he understands that this is going to be, that whatever time we choose to come back here is going to be a time that we're going to need to have some good reports. I would agree that that's not the best report in the world, but I do think that it's a lot of the issues are reflective of what happened prior to this new charge arising, and so maybe it's, this issue will be helping motivate him to turn the corner. So we were willing to waive time constraints on the preliminary hearing to get an amount of time that the court would like to see to come in with a successful report, and just would do that.
What's the state's position?
Well, Your Honor, I was mistaken previously. I thought that since he had a new monitor on, that Common Pleas Court must have been involved and made that decision. I don't recall that issue being before the court previously, but...
It wasn't.
Okay, so anyway, they took it upon themselves to go ahead and put a new monitor on, I guess.
I think they just swapped it out.
Yeah, they just swapped it.
So... the offense is against this court, and we're encouraged by the fact that he's in treatment. We want him to be in treatment. I guess we're in a position where if the court felt that it was appropriate to keep the case here, we can take it to the grand jury if it's deemed that the offense against the court is such that that's what it deserves. Or we'd be okay with leaving it here and letting him try to be successful.
I'm okay with giving him another chance. I mean, to me, my read on this is Mr. Hill was half-hearted about his efforts before he, and this is, you're not the first. It's not my first rodeo, so I've seen this attitude before. Like, I kind of want to act like I'm doing treatment because I don't really want to go to prison or be in jail, but I want to dictate the terms. I want to tell you what I'm going to do. I want to go live with my mom. I want to do this. I want to do that, rather than saying, I'm here. My recovery is the most important thing. I'm going to do whatever it takes to get clean and stay clean. You haven't been there. You haven't been demonstrating that at this point. Now, well, I do see people flip the switch. At some point, the switch has to flip, and you have to do this for yourself.
You're right.
For me, I'm okay with you starting out doing it because you're afraid of going to jail. But at some point, your brain's got to get clear enough to think, you know what? I got to do this for me. Because if I don't, my life is going to suck or I'm going to die. Those are your two choices. You're going to have a really bad life if you live, or a really good chance you're going to die because of fentanyl. So, which is it? And time's going to tell. I mean, we let you go back to treatment and you're still playing games and still wanting, you know, what you want and want to go live with mom. That's not going to work.
You're right, Your Honor. And that was my, when you first sent me back, it wasn't my attitude, was half-hearted. I got 31 days clean today. That feels pretty good. And I got my first chip. That felt pretty good. I've been enjoying treatment, actually. I know the report doesn't seem, you know, as full throttle as what you were expecting. I kind of broke my heart a little bit to see as it was, because I didn't mention, I mentioned the whole thing about going to my mom's prior to this ankle monitor thing. I only mentioned it one time. That was just because my son's starting school back, and I didn't bring it up again because I asked if I could come here and sit in court and make the request, and I don't know, I think it got a little misconstrued. But I mean, you're right. Me being sober is the most important thing, because that's the only way I'm going to be able to take care of my son. And I don't have a job besides being a father, and you know, being, you know, respectful to the Lord and all that. But being a father is my, you know, regardless of employment or not, that's my job. And I'm thankful that I have a mom and dad right now that is filling that spot for me, because I'm getting a lot out of treatment. Actually, I opened up to it. And I actually got to lead an NA class, and I've enjoyed that. And, you know, there at first it was a little rough, but I'm going to PATH as well. And they got me on some medicine there. I'm doing the MAP program. I enjoy group because, you know, I mean, it's really like it's the recreation of the place to do. You know, I get it. I mean, I didn't get to present last week, and that kind of broke my heart a little bit, because I found that being on, you know, giving honest testimony in the group is the key to, as far as I go anyway, the key to the rehab part for me, because it's allowed me to realize the answers to questions in the books a lot easier, and I am getting a lot out of it. I mean, I'm really I'm mad at myself. I'm kind of brokenhearted today, but at the same time, I'm hopeful. My integrity is good. I know my integrity is good, and I can say that with complete honesty to you, that I do want to get treatment done, and I would like to complete it, and because I've missed a lot of court dates before with you, and you gave me, whenever you gave me this last chance, I know the report kind of is half-hearted there, but I did take it serious, and PATH has got me on some medicine, and I'm not depressed no more. You know, I'm come out of that. So you know, I got my first pass coming, I earned through the program this weekend. I mean, I don't know how that'll work now, if I'm allowed to do that or not, but I am earning there. I mean, I do my chores. I haven't been in, I like all the guys there. The staff has been always helpful to me. I respect them. I respect you in the courts. And I mean, I would really appreciate and we'll put the effort in that you're requiring of me if I can continue treatment.
Okay, well, you're saying all the right things. Everything you said sounded really good to me, and time's gonna tell. I'm giving you the chance to go back and show me, talk's cheap.
Yes, sir.
Show me.
Yes, sir.
Show me what you do.
Yes, sir.
Don't tell me what you're gonna do, show me what you're gonna do, but I like your attitude at this point, and we'll come back and hopefully get a better report, and if you do really well, I think this case could take care of itself if it gets dismissed. So
Yes, Your Honor.
that would be wonderful.
That'd be wonderful.
For you. So,
It'd be wonderful, because there's one charge on my record, it's a possession charge, and I'm eligible to get that off of there. And that's just something I'd like to work on while I'm here in treatment as well.
Okay.
And I wouldn't have a record at all. I mean, that'd be awesome, to be able to put on a, I'd have a clean record.
Yeah, and you'll have lots of opportunities. There's lots of jobs out there now that are begging for people. So
Yeah.
you're gonna have opportunity, and I like what you said about being a father. That's a very important job, but you can't be a good father if you're using.
That's right, because my son's 9 years old and he's smart, and I don't want him. I don't go out and commit crimes anymore and do things like that, like I had before in my life. And a lot of, I got to be honest with you, a lot of that's come from just the hard-headed way of learning to not be that way. I mean, I don't have that in me to want to be like that at all. I don't want to, I'm not a criminal. I'm a lazy person sometimes. But as far as who I am as a 34-year-old adult, I know I have it in me to be a full-time father and a person who is acceptable in the community. And I don't want my son to have his head down at school and things like that. The only way he's going to grow up to be a good young man is if I'm a good old man. So that's what I would like to.
I'll say amen to everything you're saying there. I absolutely agree with you. So give you the chance, show me what you can do, and see you in about a month.
Yes, sir.
Another report, and hopefully it'll be a lot better report.
Yes, sir, it will be, sir.
Would you like to stick with the 8th for this, Your Honor?
I'm sorry?
Stick with the 8th?
Yes, September the 8th, on all of his cases.
Thank you.
You're welcome. Good luck, sir.
Thank you.
Keep working.
Yes, sir, I will, sir.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Andrew Curry, case number CRA 23464, A, B, and C, CRB 23463.
Mr. Steyer's case.
Real good report.
I'm still waiting on you to contact me after 6 days, and when I talk to him on the phone, he says he's going to contact me.
Well, I don't know anything until I get the report. I'll talk to you.
I'll come out and
talk to you. Nothing's going to happen on the charges. We get a report on the treatment. Unless you want to plead guilty. Then he's good.
I'm just trying to talk to you.
I'll come talk to you. I'll talk to you out there. I'll come talk to you in a minute or two.
I think I want this recalled.
I think we'll actually have this recalled for good, Your Honor.
Case will be recalled.
Just wait for me out in the lobby. I'll talk to you in a minute or two.
State of Ohio versus Trevor Dement, case number CRA 23380, CRB 21167, CRA 2630, and others.
Who's the one from OVP and then, other people with,
That's a
Pat,
screen.
today or tomorrow, phone interview. Yeah, she gave, I left it at home.
This has been coming in the
but,
screen.
I can bring it back if I have to.
I'm sorry.
He hasn't been coming in screening.
I have a letter here from OVP that states that he's been screening with them, but he doesn't have the report of that.
I left it at home,
attached.
and the lady up front, that's all she gave me this morning. I have it in my mom's car.
I had a note that he was supposed to be here Monday, Wednesdays, and Fridays for a hearing experience.
I missed Monday and Wednesday this week. I've had my kids, and it's just a lot has been going on at home.
He did screen today and he was clean.
Yes, sir. And I have a path interview over the phone tomorrow, today or tomorrow sometime.
Probably gonna be today since it's Friday.
Yeah.
You need to get that done today.
It was supposed to have been yesterday, and they didn't call the right number. I had an old number on there.
This says that there's urine results.
Yeah, he just said that he has those in there in his mother's car.
I picked that up this morning. I left it at home, so I called him and I picked that up this morning.
What I would suggest to Mr. Dement for the court to go along with this would be that when he comes Monday to screen here, that he bring those and provide those to, I guess, Mr. Cooper or Mr. Major.
Okay.
Yeah, I'll bring the paper Monday.
Want to just put it on the docket, or you gonna be working Monday?
I believe it. Is Monday a holiday or something? Oh, wait,
I meant Mr. Dement.
Oh, I misunderstood, I'm sorry.
Yes, sir. It's been very hard trying to juggle everything, but I'm making it, making do.
Could you be here?
He can turn it in before court and just drop it off as long as it's positive. If he's got positive, well, by that I mean he doesn't test for anything.
Correct.
I'll bring it in whenever I screen Monday.
Do we want to set?
And I'll just get another hearing date, but he's going to drop stuff off and get screened Monday morning.
Yes.
Right, and so we're not going to put him on the docket Monday then? Okay, that's fine. Just
So
want
he
to make
can
sure I
be here as
understand.
early as, say, 7:30?
Yes, I'll come before work. I'll just have my kids full-time. It's just really...
Okay, what sort of a time frame are we looking at to come back on this, Your Honor?
September 8th.
That'd be fine. So write that down, September 8th.
Could we come back sooner than that?
We can. You want?
Well, you know, this is
25th?
a third-degree felony, and we want to be certain that Mr. Dement's going to take this seriously. I know he's trying to, you know, he's got his responsibility with his children and whatnot, but we just want to make sure that he's actually doing, we don't want it to go that long before we find out if he's been doing things the right way.
You okay with the 25th, or you want next Friday?
Well,
25th
25th,
is
2 weeks, that'd be fine.
25th then?
August, you're available then?
I am. I'm on the docket already.
August 25th will be the next hearing. But he's going to bring his results and drop them off Monday morning.
Yes, sir, I'll have it.
So bring those Monday.
Okay.
Thank you.
Thanks.
State of Ohio versus Joshua M. Hay, case number CRB 21324. In order, Mr. Walker, that's Mr. Paul, for a hearing, 245.
All right. Joshua Hay, I understand he got released to home confinement with his brother from Common Pleas. He's not in the jail anymore. Any word, comment, whatever?
No, Your Honor, I don't have any news other than what you've relayed to here.
Well, I know he's under supervision from Common Pleas. So
Yes. You may be giving me a week to try to get him here, Judge.
Well, I may give you more than that, because next Friday's going to be terrible. I mean, really terrible. How about the 21st? August 21st. Defendant's request for sentence.
Thank you, Your Honor.
And I think he's on an ankle monitor. He said he should be there. I was told he was on an ankle monitor at his brother's house, released by common police there. He had been in jail.
I will check into that.
He's got a pretrial in common police court on September the 6th. So, and that's on a 23 burglary case.
Yeah.
And I have notes that indicate we nollied, unless there's another charge and I'm not looking at the right charge, but 21 CRA 228. Is that what we're dealing with today?
No, this is set for sentencing, I think. It's probably an old case where he's supposed to bond now.
Okay.
Yes, sir, Judge.
So we don't need.
Thank you.
State of Ohio versus Austin D. Pauley, case number CRA 22-737, CRB 2262, CRB 21-246A and B, CRB 19-743.
I have a letter for him also.
Mr. Steyer's case.
Mr. Steyer.
Sorry about that, Your Honor. Well, I think he needs to do a urine screen today,
Yes, Your Honor.
and then we'll proceed from there. So go do a urine screen.
State of Ohio versus Jared Rocknon, case numbers CRB 21-597, CRB 21-598, CRC 21-2826,
There we
A,
go.
B, and C.
I was gonna say, I'm not sure which of the JRs he is, but he's one of the two JRs.
He is,
That's the other staff member.
Oh, okay.
he's appearing.
They're not
by
present at the moment.
Yes.
Your Honor, the report we have here in front of us is not exactly where we'd want to be, but I feel that we're consistently seeing some negativity here, but I'm also consistently seeing negative drug screens and then statements that he's compliant with requirements and he meets treatment services and he's obtained employment, setting goals. So I don't know what the answer here is, Your Honor. I think my interaction with him, he's interacting very regularly with me as we go through this process, and my interactions with him, he seems genuinely motivated to better himself. He's genuinely motivated to, I would say to get clean, at this point to stay clean, because he's gotten clean. At the same time, we are running into these issues where they're saying, there's negativity of attitude. Again, I don't think this is exactly what we want these reports to say, but I also don't think they're bad. They're really bad reports. They're just troubling reports, perhaps, is the way to put it.
Sounds to me like there's some progress over what it was previously. Is that
right.
correct?
I spoke with his house manager yesterday, and they said that he's been a lot more mellow as of late. He hasn't caused uprisings or anything like that. It's definitely better than what it was the past couple of times we've been here.
But he still has things to work on, including, the big one is accepting responsibility, humility, that sort of thing. Maybe still a little attitude that needs to be adjusted.
Right.
That's the way I'm thinking it. But then you've done, I don't see, before it was almost like an out-and-out revolt.
Yeah, I think there's maybe just some adjustments still to be done, but I do think he's making progress. And like I said, Mr. Rodman has maintained contact with me, without naming names, I'm going to tell you, not all my clients, when they talk to me, sound like they care about what's going on. I think they care about getting out of jail. They care about getting through their case. And I've never gotten that impression from Mr. Rodman since we've started coming back in here. I think we had a hiccup along the way and things got slowed down, but I think that part of that was maybe the rock bottom he had to hit to get bouncing in the right direction. And I think he is moving in that direction, and I think has a genuine desire to better himself, and he's taking this seriously. I think it's just some adjustments in dealing with a change in lifestyle.
All right, Mr. Rodman, do you have anything you want to say?
I agree with all those terms. There's a little hiccup with mine too on some aspects, as I just see that some areas could be a little bit more, helpful with the mental health and physical health aspect of treatment. But overall, I am taking it seriously. As this whole process, I've been in school doing social work for the last 5 hours, trying to get my social degree.
Okay, and you've got a job now, so that's right?
Yes, I work at KFC.
That's a positive thing. Mr. Heald?
I'm sure it's a struggle, and I guess, it's not unusual for us to get reports of people who have some negative things, but they still are keeping him in the program, which means that I think that they see that they can help him make improvements. So we're okay with continuing to monitor him, and I've got a waiver prepared to do that.
And we will continue to waive time constraints to accomplish that.
Okay, so last time I only gave you about 3 weeks before he came back, so this time let's go a little more than a month, because I know you're not available on the 11th. How about the 18th?
18th, I'm available. Now, I do currently have a case at 9 o'clock in Cabell County, but I'm very hopeful that that's going to go away.
Okay.
But if it doesn't, I would be a little bit late getting over here, but I would have no reason not to get over here.
Is that a Friday?
That's a Monday. Is Friday or Monday better for you with your work?
Friday, because I've had it with my work to have Fridays always off in case of court.
Okay, we'll make it the 22nd.
22nd, I'm completely available, Your Honor.
So the 22nd, that's a Friday. That'll be your next hearing. Okay, keep working on things, Mr. Rodman. And I think you have made improvements since the last time you were here.
September.
Thank you for the...
That's September 20. And I will talk to you later on, Jared, okay?
September 22nd.
22nd, I'm sorry. Yeah, I just read it wrong. I don't know what, I was even putting it on the right day on the calendar. Thank you.
You're welcome.
State of Ohio versus Roger King Jr., case number CRA 23-143.
Yeah, you're good, Jared.
Roger King Jr. Okay, so he's with Mr. Webb, and we have a preliminary hearing.
Thank you. He's completed, from what I understand, our outpatient program, but he's continuing services with us.
Okay, it looks like we've been at this since May, so that's not that long. Yeah. First report was June 27th. You did have a negative screen then. What's the state's position on it?
Well, it's a good thing that he's made it through that part of the program or to whatever completion that he's made it to. It hasn't been very long, so we would want to continue to monitor him for a while.
Yeah. This is kind of strange in that the incident was July of 2022, but the charges weren't filed until March of 2023, and then he wasn't arraigned until April 10th. This may be one that we could send to QRT if you want to talk.
I'm happy to meet with him. What are the charges?
Possession of methamphetamine, felony file.
Okay.
He's
Trying
got
to
a
remember.
Huntington address.
There were some circumstances that I don't have a note on it. That was the reason why there was a delay before it was charged.
So this may be one that you call deflection, where you go, you wouldn't come back to court anymore, you just deal with the QRT team, and it would be, as long as they're satisfied, the charges go away. You interested in that?
Yeah.
Okay, we'll have you talk to Megan, you want the court's file?
Yes, please.
Then,
Average.
yes, come back, let us know if you want to do that. We'll call you back later.
I mean, yeah.
State of Ohio recalls Austin D. Pauley, case number CRA 22737, CRA 2262, and others.
Okay, this is Mr. Steyer's case. Okay, you had a chance to talk?
I have not.
Oh, okay.
I was talking to a different client, I apologize. Have results are here?
Yes.
That come, okay. So, buprenorphine was expected, THC and alcohol not.
The alcohol is surprising to me. I've never drank a drop of alcohol in my life. You can ask Mr. Gwynn. Any assessment I've ever done, I've never had an alcohol problem ever.
And Your Honor, I've explained the importance to him of remaining compliant with treatment.
Okay, how do you want to proceed?
as long as they're still keeping him, want to keep him in their program, we don't have an opposition to that. We need a time waiver.
And we'll waive time, Your Honor.
September 18th.
So write that down.
September 18th will be the next hearing.
Thank you, Your Honor.
You're welcome.
Thank you.
Thank you, Your Honor.
State of Ohio versus Brian K. Stapleton, case number CRD 23983 A and B, and CRB 22573.
This is Mr. Morford's case.
Enforcement judge.
Well, Brian Stapleton's not here either, so he's set for sentencing. Okay, I will message Mr. Morford. And there's a trial on this 22-573.
Okay, that's set for September the 8th.
It is. That's a theft offense. Oh, yeah. It's set for a review. It must have already been a plea on that.
Yeah, he ended up, that's the one that.
Yes, he did plea. That was the Buckeye rule.
Yeah.
Okay, I'm gonna go ahead and move this is a traffic matter, this TRD 23983. I'll move it to September the 8th also for sentencing. I think it was just, he was gonna try to get his license back.
We were supposed to find out whether there was restitution, maybe an offense. There was insurance. I've noticed in the different cases where you have traffic.
State of Ohio recalls Eric L. Summers, case number CRB 2372, TRC 211980 A and B.
All right, Mr. Summers said good fortune to be able to watch all of court today. How'd you like it? Okay, let's see. You got a theft, 2372. You did do some community service since the last time you were here, August 9th and 10th. And you paid a payment today. All right. Are you working now, sir? Okay. Well, you can do community service to get toward your fines, too. Very good. September 11th will be your next hearing, 9 o'clock. Okay. You're free to go.
State of Ohio versus Timothy L. Watts at the Lawrence County Jail, case number CRA 23485.
He was going to be evaluated for treatment.
He was, Judge. I think Ted's went to inpatient treatment. Is what he's.
All right. Did you hear that, Mr. Watts?
No, I was muted at the moment.
Inpatient treatment is what's being recommended. Are you on board with that?
Yeah.
I'll pick him up today.
Okay, I'm going to order you released. We don't need an ankle monitor or anything. You're not going to run?
No.
So the best thing that could happen, this is a lot to throw at you, but you're charged with a felony, which means you could go, ultimately felonies, if you're convicted of, can go to prison, but you have to have the trial in the common pleas court. This is not the common pleas court. This is municipal court where you have arraignment and preliminary hearing. The state's agreeable to keeping your case here. If you do really well in treatment, they probably will dismiss it, so you don't go to common pleas, you don't have a risk of going to prison, you don't have a felony on your record. That sound like a good deal?
Yeah.
Okay, you gotta do your part to make that happen. You gotta go to treatment, not cause trouble, pay attention in class, do what you're supposed to, do what you're told when you're told to do it, not cause a mutiny. We've had that here recently. Can you do all that?
Yeah.
Okay. Well, time's gonna tell, because I'll see, you're gonna come back periodically, and I'll get reports as to how you're doing. Make it a good report when you come back.
What time will they get me today?
I don't know.
As soon as they have a release down there, we'll be down there pretty shortly.
It won't take too long. A couple hours maybe. Okay, August the 28th.
I'm here, Judge, yes.
August 28th will be the next hearing.
Thank you, Your Honor.
Thank you.
You're welcome.
I'll see you then. Before then.
Let's do Aaron, yeah.
State of Ohio versus Aaron Atkins, case number CRB 17972, CRB 15628.
Yes.
I just want to apologize for the condition. He's been reluctant to work in front of you, so he is in a restraint chair. No longer able to.
Okay. Okay.
I don't want to fucking talk to him. I'm fucking serious. He fucking fucked my kids over. Get him the fuck away from me.
Okay, what I'm going to do is continue it. You can bring him in person on Monday afternoon. He can sit in jail. Does he have a holder from any other?
He has a motion hearing in front of Common Police Court Monday, Your Honor.
Okay.
And a trial Friday.
All right, we'll continue it then till August the 21st.
That'll be the first, sir.
Well, we'll see what his attitude's like then. If he calms down, wants to do it by teleconference, we can. If not, we may have to bring him in person.
Yes, sir. Thank you, Judge Carter. Have a good day.
Thank you. You too. Okay, that finishes it up at the jail.
State of Ohio recalls Andrew Curry, case number CRB 23464, CRB 23463, and others.
All right, Mr. Steyer is representing Andrew Curry for a preliminary hearing.
Yes, Your Honor. The preliminary hearing is on a felony drug charge. There is also, and they're on the docket, I don't know if you have them there,
I do.
some review matters. Okay. I'm sorry, I'm discombobulated here with this. We have a report. Have you received the report?
I believe I did, yes. Dated today.
All right. So he has started at, looks like transitional living at RRS. We did have a positive screen when he went in on the 4th, but at this point, or the 9th, which I guess would have been Wednesday. So as of Wednesday, he tested negative. And there was a send-off urinalysis on the 7th, which that's between the other two, so I don't know what that's going to show, but I think it looks like we've got the drugs out of his system, and we're getting started on treatment. I don't know what the state's position is on whether it's going to want to keep these cases here. I think that would probably be a wise course of action since he has these other matters that are already before the court. They're sentenced matters, but he's on probation.
One thing you said that puzzled me, you said something about transitional or?
Residential, okay, it said transitional on the.
Okay, because I thought.
Okay, so.
Okay, I'll get that fixed.
Okay, I think it's a typo, Your Honor, I apologize.
That should be resident, I'll strike that out, residential.
So,
He's only been there a week, I think.
right, we're just getting started.
Yeah.
But, I don't know what the state's position on this is. There's I think there's a tampering with evidence, which it's hard to say on these tampering charges, sometimes from the vantage point of this court, looking at what the materials I have available to me now, whether any given tampering charge is something that's gonna actually hold up when we get to the next court, or we're gonna end up with just possession charges that we could have dealt with here. I don't know what the state's position on that is, but we're early enough in treatment, and we have these other matters that are, I don't think they're scheduled today, but they are ongoing issues.
Pre-trial review, they are.
Pre-trial under review, that at least temporarily, I think it would be wise to keep this case here, track his progress, and avoid clogging up the common pleas court, see how he does.
Up this court.
Well, he's gonna be here anyway, though.
Okay.
Even if we send him on to the common pleas court, he's gonna be here on reviews on these other matters.
We have a lot more cases than they do anyway.
That's true. But sending him on wouldn't actually save us a case. It would save us a case, it wouldn't save us a defendant. So that would be my preference, at least for the moment, and we don't necessarily seek a decision, a long-term decision and commitment from the state at this point. But I told him that even if they don't agree right now that they're going to keep the case here forever, if we keep coming back and he does well enough, at some point they're going to say, well, heck, he's done well, let's do something.
Let's see what he can do.
And that's what I'm saying.
Tell me what you can do.
That's what I'm saying.
Says Mr. Hill.
On behalf of the state, I've struggled with what to do with this, because there are a number of felonies. There's an open dumping charge, which it is not uncommon for us to agree to leave the case here.
Is this one with the co-defendant we had this morning, and they
Yes.
said they were going to go work on it?
Yes, so he might benefit from the fact that the young lady's going to go do the picking up.
I tell you, she looked tremendously better today.
We've got
Big difference.
resisting arrest, and this was not just a pull your arm away resisting arrest. This was, they had to chase him down and tackle him, it looks like. Tampering with evidence, which is a third-degree felony, and the possession charge, and it also appears that Mr. Curry has been through the court system before in the past, and not just once. So all of those things, we want him to get in treatment. We want to get this cleaned up. We're going to want him, if we keep these cases here, we're not going to just let go of them completely and dismiss everything and act like it didn't happen. So we're willing to give him a chance, but he's going to have to understand that at some point we're going to deal with the resisting arrest, and we're going to deal with the open dumping.
The only thing I would say regarding the open dumping issue, Your Honor, is that while he's in inpatient rehab, we're limited in what we can do about the open dumping situation. Our normal course I'm saying that for Mr. Hill's benefit. Our normal course is not going to be available to us while he's in rehab.
Now, I will say that the other counseling agency that has the young lady had said they would help her get out there.
To go after court today to clean some of that up.
So that would be real.
I know you're on a monitor. And he is on a monitor, so I don't know. I mean, that's got to be his ability to go there is going to be arranged through Mr. Bowen. So that complicates things as
I mean, at
well.
some point, that kind of stuff should be doable where he can go work on that as a project.
Right, but it's not something we can say, I can say, oh, he can come in a week and have that cleaned up. I'm not in that position, which I normally would like to be in an open dumping situation. So again, recognizing what the state's saying, I think our best course of action right now is to go out a couple weeks, give him a little bit of time to get himself established in treatment. And then we can look at where he is, and if he's doing well, the state can continue to push the ball down the road. And I've told him, even if the state doesn't make an absolute commitment, the longer he does well, the better a chance we have to keep the case here. And, frankly, if he does well and they decide to take it on to the next court, he's going to be in better position in the next court anyway.
So either way, it's going to help him if he gets good reports.
Correct.
Either court.
That's my position.
They've got enough people that screw up that they have to deal with. Don't be one of those people. Same thing here. You come in with good reports, that can only help you. So, at this point, sounds like the state's okay with leaving it here, but not making a promise that they're gonna keep it here forever. But open to being persuaded, sounds like.
Well, it's going to depend on what happens from here forward. We get a bad report or he has a bad attitude, we might change our minds.
Right.
If you want to fight the case, we can fight the case. I hear you. But we've got to decide whether we want to fight the case or we want to try to keep it here. Those are our options. We can't do both. Okay? And we don't have to make that decision for sure right now either, just like he doesn't have to make a commitment. We can take a try at this, see how you're doing, and if you're doing well at it, you might find that you're feeling better, thinking better, and want to continue on with this and get rid of these charges. There's a way to get rid of these charges down the road, okay? That's what we're aiming for. Okay? All right. So I would ask for a continuance, and we would waive time constraints to accomplish that. And I would leave it at the court's discretion how far I have to go. I would think give them a couple weeks at least to get some distance
How
up.
about are you here the 28th?
Of this month?
Yes.
I believe I am, but let me make certain of that.
It's a little more than 2 weeks.
I'm on the wrong month here. Nope, I'm on the docket already, Your Honor.
Okay, that's the best date for the court, August 28th. So all his cases are set then.
I'm sorry?
I can't say no.
If you want to say something, you can say something, but I'm going to
I know.
caution you that it could hurt the case.
It ain't gonna hurt the case, what I'm about to say.
Okay, go ahead.
As I told you before, when I did the interview over the monitor while I was in jail, I do yard sale stuff. They think that open dumping is yard sale, it's my yard sale stuff. That's how I make my money. I have no income. My old fiance was Tony Walter. She has the income. I do not. That's what I do. I got 300 pumpkins over growing right now that probably going to go bad, which I can sell for $5 a piece and get $1,500, which will pay for the court. I do construction work, like with my hands. The monitor stops me from going to get that job and paying the court. I got 3 jobs on in Proctorville, hanging walls and doing flooring, roofing, siding. I'm not stupid. I messed up with the drug thing. Yes, I did.
I'm going to caution you not to say things that might be incriminating.
I'm grown.
I recognize that, but I've got a job to do, and part of my job is to give you that caution, and you, as a grown man, make the decision on what you say. Okay, that you can say anything you want, but I've got to do my job and say, hey, that might not be a good thing to say.
I understand that.
Okay, that's all I'm saying to you. And I believe, I mean, I can't speak for the court, but I think our general thought process in this courtroom is that even restitution can be pushed out while we deal with the immediate issue, which is treatment.
Your recovery is number one.
I know that.
That's the number one thing.
I got my first check.
We'll worry about the other stuff later. But that's, it doesn't matter to me if you can pay restitution or not. Well, it matters less than your recovery. So I'm not going to say, oh, well, we got to have that money. I don't really care about that. Right now, I want to get you clean.
I know.
So that you're clean long term.
I've been 7 days clean. I got my first chip and I got my sponsor on the way.
Well, that's a good start, but you got a ways to go. You got work to do. You've got work to do.
And I ain't had no money in that woman.
So far, I'm getting a good, well, you got a place to live and sleep and eat.
I do, my rent's due, which is due Mike Finley, the county commissioner, and my rent is due. So I might not have a home to go to, so y'all might want to replace me a house or something, because I might need one.
I think there's some placement services
Once he takes my home off that property, I have nowhere else to live.
Well, there's placement services down the road if that's what we need.
I understand that, but if I pay $800, I can pay $250.
I understand, sir.
We can't dismiss your case because you
I
got a
understand
problem
that. I know
with
that.
your rent.
I know that. I understand that, sir. I know that.
All right, I understand there's a lot. You got a lot to deal with, and that's one of the things that's concerning you.
That's why.
Again, back to what I said before, your recovery has to be number one.
And you're off to a good start.
I know.
Okay, that's all.
Thank you.
State of Ohio recalls Robert King Jr., case number CRA 23143. Okay, well, we were letting Mr. King be evaluated for QRT.
Your Honor, he expressed that he is not interested in moving forward with
Okay.
QRT at this time. He just expressed an interest in wanting to wrap this up as soon as possible.
Well, he's only started recently, so no.
I
Okay, you
have
can
no
come
way
back
to
here.
get there and back and forth.
Okay.
That's setting me up for failure. I'm homeless, I have no car,
Where are you living now?
I'm couch surfing anywhere I can. That's
Well,
why I missed
get out there
my
and
one.
get a job.
I have a job, but it's not paying enough. I'm doing everything I possibly can. I have been. I've bent over backwards. I've done everything possible. I've tried to keep jobs.
Well, do you want, maybe we get you in a sober living facility where you don't have to worry about your rent. Or an inpatient treatment facility. I mean, you've only been at this since, you got
I'm
arraigned April 5th.
I'm fine with doing therapy like I have been doing, but I can't go to Ironton.
Okay, that's fine. I just thought less restrictive, because you, from the reports I got, it seemed like you were doing well, and your problem maybe is not as serious as some other folks, and maybe you didn't need as much supervision, but if that's gonna be worse for you, you don't have to do it. We'll just keep it the way it is.
I mean, the only issue I have is going every single week. If I could go every other week, that would even be better.
Okay, well,
But
that's not what the program's about. You can come back here like you've been doing.
let's keep coming back here every 3 months.
And if there's a way, can we help him find housing? Can we help him, there's jobs out there. We can help you find a job. What can we do to get you where you need to be?
He could go into sober living. I thought I picked him up at his parents' house, kind of found out it was his sister's home. And I got to meet his dog this morning. He has an elderly dog that struggles with his back two legs, getting in and out of the house and stuff like that, which I got to meet him this morning, and I offered him sober living. He said, man, my dog's a damn. He said, I've been with that dog forever. He said, I'm not going to give up my dog and go sober living right now. It's like, and being a dog lover, I can't imagine. So I was like, I totally
That's my
understand
child.
if there's any way I can help. But he
Tell
even
them
told
with the Harmony
He's
House.
a therapy dog.
He is.
I got that dog when I tried to commit suicide. He is a therapy dog. There's no way I can separate that dog from myself.
Okay, that's fine.
It is a therapy dog, I do know.
Are you familiar with the Harmony House in Huntington?
No, I'm not.
Okay.
I've heard the name, but I know nothing about it.
It is down on 4th Avenue and 7th Street. It's right across from the courthouse on a little side street. They can-
Housing, I don't need assistance with housing.
Okay.
I need a program that I can get to and get back and forth from, not Ironton.
Well,
I even walk here to this courthouse from occasion from Huntington
That's not
and
that-
back and forth.
that's not
It's not
that
that far, but when you're going across these bridges, it's a bitch. My apologies.
Okay, well, you're getting treatment with RRG. How's that working?
It's great.
Okay.
I love my therapist. I love everybody there.
Well, let's just continue things the way they are.
I'm perfectly fine with that.
I thought I was doing something that would be
I
less
appreciate
restrictive
that,
for you,
but
so that's
I
okay.
appreciate that, but I'm happy where I'm at.
All right, we'll keep it the way it is then.
Thank you.
And I'll see you in 6 weeks.
Yes, sir.
That's September 22nd. Okay, keep doing what you're doing. You're welcome. All right, court's adjourned.
Time flies.